That's what they're requesting
Didn't do any work.
for the permanent change, right?
Yeah, yeah, just tell them
To change it from committee member to chair.
yeah.
I didn't realize that about academic.
Yeah, you had to have 3.
Clerk, may I have a roll call, please?
Committee Member Duishak.
Present.
Committee Member Whittam.
Here.
Committee Member Maruko.
Here.
Committee Member Narayan absent. Committee Member Prinzler absent. Committee Member Young.
Here.
Committee Member Kilroy.
Here.
And Chair Stressenberg.
Here. Thank you. Please rise for a salute to the flag. I'll lead that. This flag, place your right hand over your heart. Ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. Is there a motion and second to approve the order of agenda?
Second.
All in favor? Aye. Any opposed? Passes unanimously. Blue folder items. Can Can blue folder items be attached to the agenda prior to being received by and filed by the committee?
Once we email to the committee, it needs to go onto the website. Is that what you're asking?
Yeah, under the individual items where they're
Correct.
intended. Okay, so that's when they go on. So it can be before we actually do the receive and file.
Correct. Yeah, because there's a law that within 24 hours that the supplemental materials go to the committee members, it has to be public.
Okay. I would like to pull the item for I2 as that was distributed without the express permission of the originator.
So you're talking about regarding the resolution?
Mm-hmm.
Okay.
Point of clarification, I don't know if you can pull it, but I think you can recommend that we not receive and file it for those reasons. It's not like it's a consent calendar item.
If you don't want to receive and file, it's sort of already public because you provided the email saying,
And I did so in error because the email explicitly said that I cannot distribute it without the express permission of the author.
I see. Okay.
So I would move that we not receive and file then item I2. And I would think for the reasons that you
receive and
stated, that other people would agree that that should not be received and filed. You just need a second.
I'll just pull it. I don't know.
Distinguish yourself.
Okay, there's a motion. Is there a second?
Distinguish.
So we will receive and file the item for I3.
So moved.
Second.
We're receiving I2 and not
We're receiving I3, but not I2.
I3, okay, that's okay.
Okay.
Try not to look at I2.
Okay, all in favor?
Aye.
Aye.
No public comment.
None opposed? I don't think we do blue folder for public. Do we do public comment on blue folder?
No.
I think so. All right, consent calendar. We have items F1 and F2. Anyone like to pull any of those? I would like to pull F2. So is there a motion and second to approve F1?
So moved.
Second.
Motion second, all in favor?
Aye.
Aye. Any opposed? Passes unanimously. For the meeting minutes that are attached for June and I think May it was. Was there a change to who was writing the meeting minutes?
Yes.
Because I'm finding, and I know I made a comment a couple months ago how excellent the meeting minutes were. When I read these, it's difficult for me to determine what was really said.
Okay.
You know, there's notes on things, but it's not really helpful, I would say, would be one way to put it. So it makes a lot of statements, but I don't really know what was done.
Okay. I can go back to it and put
So
more
like
detail.
having additional information to finalize election language. And that's falls under something else, but that's just by itself. And clarification on the client regarding making the decision on who chooses the hired legal group. It states something, but I can't tell from this what was really said. I mean, if the committee wants to accept them, that's up to the committee, but they were
Get
outstanding
a little bit more
before.
detail. Yeah, because it was way detailed than what we
You can tell that it was-
normally do, because
that's
we
why I asked
normally don't do
The question
detail, but
originally was,
I will see if we can get a little bit more detail on these minutes.
yeah,
fine.
it's written almost, I don't know, kind of disconnected in both of these.
Can you state which,
How-
what one you're looking at right now with?
This, I've got the May open right now.
How long are the videotapes or electronic recordings archived for? As long as the minutes? I mean, in comparison.
I mean,
Let's
They're forever.
let's say in 20 years, somebody wants to look at the minutes, all right?
right.
Will the electronic copy of I assume the minutes was taken from,
Well,
be available to them?
well, actually, our destruction is 20 years, so yes. But after the 20 years, no.
20 years for the minutes and the tape? Or
No,
20
20
years for the
years,
minutes
the
or
minutes
or
are-
the tape?
The minutes are permanent, so you will see
Okay,
those.
that's what I thought, but okay,
And then the video is 20 years.
okay.
Yeah, and I get what you're saying, because you can always go to the video,
Right.
and that's what I had to do in a lot of these
I
cases.
understand that, but I wanted to know if
Understood.
if they were around forever. So let's just say the next charter review
Is
wants
what
to
I'm
look at the
thinking of.
minutes, they can't understand the minutes, has the same dilemma you have. Is there a videotape? And 20 years in one day,
Which is close to where we're at with the prior.
exactly, that's why I brought it up.
So that's why I did put some considerable importance to these, because I do go back to those other minutes from the prior charter review. And
I'll go back and have,
if you can take a look at it, and I can go over a few more things as examples if you want to, but
no, I can, I
Is
know
the
what you're looking
destruction
for.
state law?
It's, the destruction, there's some that are based on the law, some
Well,
of
in
it's
the
based
case
on
of
the
the
department.
videotape, in the case of the videotape, is it state law?
We
So
it used to be 5 years and council decided to do it 20.
So the council could decide indefinitely,
Down the line, yes, they can,
something to think about.
yes.
And the written minutes are the official record regardless of what the video says.
I didn't say,
I
I'm
understand,
not
but-
challenging, I'm not challenging it, but if you can't understand we're living in the 21st century. So if we're going to say the written minutes are rule, that worked in 1947. But, I'm not sure it works in 2023, excuse me.
yeah, so just another quick example. One of the statements here is the difference between the city attorney choosing appropriate legal counsel when needed, depending on the topic and questions from staff, and choosing legal counsel for litigation. It says something, but I'm not sure what,
Pertaining to.
yeah, what it's really trying to say.
Okay.
The context, I guess, is what's missing here, is that, so if you would take a look at it,
Sure.
I'm happy to discuss it with you outside of this too, if
Okay,
you want.
sounds good.
So I would make a motion to bring these back. Can you do it?
Second?
Yeah, the next meeting,
Okay.
yeah. Oh, yeah. Now that I have chief deputy and hopefully one more person, I can breathe and I can.
So the chair makes motions now? Is that just tonight or what?
You can make a motion.
Okay. I don't remember that rule, but okay.
No, I can vote too.
Some things are shameful.
Well, it's always been that way.
Okay.
As you said, this is 21st century.
Yeah, that's what I said.
Okay, so there's a motion, a second was there a second?
Yes.
Ms. Morocco.
I don't know if I was, but.
To bring back the minutes from May 25th and June 22nd of the 23 regular meetings revised in accordance with the discussion we've had, to try to get a little more context to the content, I guess would be a way to put it.
You could have said just more accurate.
More accurate is another way to put it. Thank you.
That's what you want.
Your question?
Detail.
Well, the comment, you can create a minute committee to work with the clerk's office so that before it actually gets out to the public, you have an opportunity to go over and get it to the point where you feel comfortable with it.
Okay.
I'm just
Appreciate
saying
that.
if that's what you want to ultimately.
No, I think we can get to back to where we were before.
Okay, yep.
I think it's understood. So all in favor?
Aye.
Any opposed? All right, passes unanimously. So that was under excluded consent calendar items. G, we just covered that. It's a matter of F2. H, public participation on non-agenda items. Each person will have 3 minutes to speak on any subject.
Oh, actually, just for the record, we have no e-comments or public comments.
On consent calendar. Thank you. I did not. I will do better with that. So each person will afforded 3 minutes, up to 30 minutes for each section. Do you have any e-comments or online?
Nope.
Okay, so hearing none, we will move on to items. I1, continued from previous agenda, discussion of possible action as it pertains to moral turpitude, clarifying residency requirements and analysis pertaining to extending the required residency period for elective office from 30 days to 1 year as directed by City Council. Mr. Morocco, I think we.
So I met with committee member Deweziak and we discussed it and we got into a lot of the weeds, I think, and some of the more modern issues, and really it makes some sense to get some guidance. We were looking at what happens if you're homeless and what, you know, if you live on a park bench in the city or you've been a resident. So we started hitting in some of the gray areas, and I think, and committee member Deweziak can correct me, that we ultimately decided that maybe you just need to let the process work out and there's no need for a specific definition of residence, because if you're looking in the charter for something, it may not be something that works well, and then maybe focus, at least this is my perspective, focus on creating a process so that there's a way to actually authenticate it without having to drag everything through the courts. I don't know if that's your recollection.
Well, I have a little bit of a different take on what was said. I think that we should have definite words. And if people want to attack the words, I think that that's fair. In other words, we say you have to be a Redondo resident. And if we don't define it down past living in whatever your constituency is, living in the city if you're the clerk, living in a council district if you are running for a city council seat. I think we have to have rules of what people can do. And I go even further because I think that there should be, I hate to use this word, educational requirement, phrase, actually not a word, educational requirements. You should have a demonstrated knowledge of, say, civics. So if you graduated from high school in California, that might qualify you as a candidate for office, for elected office. Just, you know, the city attorney, the clerk, and the treasurer obviously would, and obviously in my mind, have a higher educational threshold. I'm not interested in having people who sleep on benches representing anybody, not because they sleep on benches, but because they're not representative of the city as a whole. I'm not trying to deny people office. I'm just saying there are parameters that we should set for holding office. Let's say being a registered voter would be one. So if you meet the qualifications, 18, age of majority or above would be another. Having a residence in, like I said, in the political boundaries for which you seek office would be another. So I'm not so much, you know, if people want to challenge the word residency, I say have at it. So, you know, and we define the residency when that obstacle comes up. If somebody says, well, I am a resident because I live under this tree, I say, yeah, okay, but does the post office deliver mail there? I mean, in other words, the Miracle on 34th Street solution. So I'm not just willing to say, well, we don't need anything. We need parameters. We need to have I'll just say language that says, these are what you should do for an office. In other words, like I said, I'm in favor of everybody in California that graduates from high school having taken the test that we give to immigrants, just to prove that they understand the same thing that we demand of other people who seek citizenship. I'm a person that's of the belief that citizenship has privilege attached to it. And there's no privilege if you haven't really, I'll just say, demonstrated what that privilege means to you. So if you're not a voter or are able to be a voter, you're not qualified for office. If you don't have a residency in the stakeholders whom you're asking to put you in a certain office, you don't qualify. You know, and I've said this before at these meetings, you know, we have a saying in the Marine Corps, you're either qualified or you're not. So you don't get to state what the qualifications are. So I'm in favor of putting in the charter qualifications. I'm not tied to the wording of those qualifications, but I am tied to having parameters or I'll just say qualifications, as loose as they may be, and we can argue over that. But I don't think that we can just say, you know, we don't care who raises their hand because, well, we'll get sued by, you know, we're going to get sued anyway. I mean, it's like, you know, if somebody has a bone to pick with you and you have deep pockets, guess what? They'll be down at the courthouse and thinking, how can we get money out of you? I've told my kids, life is a game. Who has the money, who gets it, you know? And so, you know, if we don't have people who are willing to stand up and say, okay, we'll fight, this is a fighting point, and we're not going anywhere. So that's my opinion.
Okay, Ms. Morocco.
But I do want to emphasize that we're looking at two different criteria. One, to become an elected official, and I agree with you completely that you can spell out the qualifications. I think it's pretty clear on the qualifications to become. Is this the question at the end of the day to remove somebody from the position? The examples that come up, you know, if there's a storm that all of a sudden flushes somebody out of District 1 and they have to move to District 2 temporarily, would that eliminate them from actually continuing to serve? So
we had that discussion at length, as you might imagine. So I'm not so much, if a person is qualified for an office and they are holding the office and then circumstances out of their control, and that's the key phrase, they're out of their control, force them to seek a domicile somewhere else, I would say, I think that's a council decision and not a decision for the charter. The sitting council should make that decision. So I don't think, because again, acts of God, you know, tsunamis, whatever you want to throw at it, you know, the hurricane that we just had last week, you know, didn't really wash anybody out of anything. So I think that could be worked out. I think you just leave that alone and give it to punt that ball to the sitting city council.
Okay.
and I just point out that that's exactly what we have right now. It's the city council can decide. And so we really don't have to do anything, but I think it'd be nice to have some sort of process put in the charter so that.
Well, I don't think it belongs in the charter because it's such a, I'll just say, unlikable event. And I know it just happened, but I'm not, you know, that happened not because of anybody's fault, but I think it happened because of haphazard thinking of what you can get away with. In other words, I'm a city council member and I'm doing this, and you know my political enemies are doing that. That's why it's a political decision. So I don't think that belongs in the cut and dry. If you're qualified to hold office, you're qualified to hold office. That's the end of it. I mean, that's, so, but if circumstances change, not due to your, any of your doing, in other words, I'm trying not to draw upon the past, the recent past, but if it's not of anybody's individual doing, or something they could have corrected, or something they could have, that's a judgment call, and I think that should be left to the city council.
For our new members, I'm going to recap just briefly where we're at on this, the overall subject matter here. We have three things. We have residency, moral turpitude, and the 30 days issued for how long residency required. So we have the definition of what is residency issue. And along with that, we also had, and we still need to address, I believe, that different offices had different requirements for maintaining residency. Is that something we may still want to clean up? Maybe we don't, but we should look to the end
Cleanup
result.
sounds like there's something wrong with it. And so I'm not willing to buy that language for the minutes purpose.
Then change.
You want change. I don't necessarily want change.
But that's one of the things I'm just recapping some of the discussion.
But you phrased it in a way that will go into the minutes and the record will be in 20 years and we'll be reading it. So I'm a little concerned now that you brought up that.
So where we had left off moral turpitude was that we didn't see that it would be appropriate to expand a definition of that the case law defines that. Mr. City Attorney, if you want to jump in on that one as a legal issue, that case law was really the better thing to rely upon, because that the law may change, and for moral turpitude, law may change, and that if we put in some further definition or something greater than that, within the charter, it could become problematic.
Right, and it's also hard to come up with a better definition of it. And so it comes up most frequently in state court in criminal cases, because it has to do with the impeachment of witnesses. And you can impeach them if they have a prior conviction for moral turpitude. So there is a very robust case law, which I provided. It's in the past minutes to all of you, of cases that are moral turpitude, that have not been determined to be moral turpitude, and that will grow over time. And I think the consensus of the committee was, we probably can't do better than the case law, as incomplete as it is, we probably can't do better. And the one time it came up, the AG's office opined that the council got it wrong, and that in that case, it was clearly moral turpitude. And so I think if they look at case laws, future councils can look at case law and determine based on the nearest comparison, or it may be the exact charge for which they're convicted. I don't think that's something that we can, the committee can add clarity to. The other issue, I think, the committee very much could add clarity to, in terms of what the definition is that the council has to look at. Because if it's just a political decision, okay, but ultimately that can be challenged in court.
For residency or what?
For, what the standard is to remove. And so we don't have a definition of residency. And so I provided the committee many different state code sections that use different definition of residency. And in some cases, they use different definitions for a mayor in a general law city compared to a city council person in a general law city. Addressing the homeless issue, one of the options is, and I'm not arguing for any option, but to tie it to either exclusively or combination, that they remain an elector of the city of Redondo Beach, because the state Secretary of State has specific guidelines on that you can register to vote if you're homeless. And they ask for a place you can receive mail, But if not, you can use cross streets, you can use a park bench, because they need to know what precinct to put you in for the election. And I think it'd be hard for us to come up with something. And so it could be that, although it could change over time, it's a risk you take when you rely on state law, at least it will be more certain.
Well, the issue of being an elector, it's a shame I sit on the left. You know, I'm so far right.
You guys,
The residency or being an elector, I would, you know, I would have language, if we were in favor of putting language in that narrowed that, I would be in favor of saying you had to be an elector in the particular district that you were running for, and I would say a year. But I mean, you know, you could whittle it to 6 months, or you could make it 2 years. I mean, the county of Los Angeles has some requirements that are 2-year residents, just to be on a committee like this. So, you know, that's how I would solve that problem.
and that's the other aspect that we did talk about that I was going to talk about. The 30-day, we had talked about, would we increase that?
Too short.
And I believe the consensus of the committee was it wasn't going to really be in a good direction to make it longer, is my recollection of this.
It didn't change my opinion, though.
That's understood.
What do you mean by that? It wouldn't be in a good direction to change it.
Well, we had looked at, well, would we make it 2 years? And I don't remember if there was particular matters of law that came into play there, but it seemed like it became more problematic than beneficial.
From a legal point of view.
From a legal point of view, yeah, it's a fundamental right to run for office. And if you tie it to something like 2 years, that likely will be struck down.
About a year.
Well, that was the discussion.
Less likely to be
That
struck
was the
down.
discussion that the committee had, and the committee decided it's not worth. Now you can change and direct me to go.
I guess that goes to your point that anybody who sleeps on a bench or can establish a residency has the right to run for office. And my point is, those people are not representative of the constituency as a whole. I mean, they certainly are a part of the constituency, but they don't have the same mindset for the development of the city that somebody that owns a house on Avenue B.
Voters to
I
decide.
was just going to make that same point.
That's for the voters to decide.
For the voters to
That's
decide.
it. I don't disagree with that. And it's for the voters to decide whether or not we put qualifications on there too. That's what this is all about. So if the voters are going to decide one thing, they get to decide something else first.
Is there state law that you have to be a resident of, for example, District 5 if you run for District 5? Or is that purely a local?
That's a local law. For example, it depends on the level of government. So we have districts, so you have to be in the district. Some, school board, you can, live anywhere in the city. If you run for Congress, you have to live in the state. You don't have to live in the district that you represent. And that's because there is no such requirement in the U.S. Constitution. So it's always the appropriate level for their elected office.
But there is no.
Which sets the rules.
Because I think I have seen that you could run for office for a certain district, but not live in that district in other areas. I do believe I have come across that, but that's what I'm asking. I don't think there's a state law that says that you have to.
There wouldn't be, because it's up to the local entities. It'd be a charter city that would set it, because general law cities are controlled by the applicable state law. But for charter cities, it's a charter, it's a municipal affair. And so some of the lawsuits that the cities fought have been specifically about its city charter control over, how and when our elected officials are represented.
Do you have a memory of when Councilman Member Mitchell was convicted of federal mail fraud and went off to prison in that fight? Okay.
That's
Look that
moral
up.
That would be moral turpitude.
Did he lose it due to residency or moral turpitude?
Residency
I
issue.
do have a memory, when I
Residency.
when I was on the county
It may
prosecutor.
have been a moral turpitude issue as well, but it was also a residency.
Well, the first one that I saw come up, there's a state law, if you have to live in your assembly district. And the DA prosecuted, which hadn't happened before, someone, and they showed the evidence from that case, and they referred to it as the bathroom cabinet that time forgot. So the assembly person had a district home that no one lived in, and then had a very nice home in a nearby district. And so they had a bathroom cabinet that had a bunch of like Right Guard in a can, an aerosol can. They had, proof that this hasn't been sold in 20 years. No one's living in that. And they had a former, I think, lieutenant governor who was willing to testify as an expert witness that everybody does that. And it was excluded by the court. So those were the first times that was started to be enforced by the prosecutors.
I've never done it.
On a legal basis, could a definition of residency be established by the city council by ordinance or resolution? Does it have to be further prescribed within the charter?
Theoretically, it could be, but the problem is to remove someone, it's in the charter. So if you wanted to clarify, because we're talking about the different sections where a vacancy is declared by the council, and you want that to be set in stone because you don't want a council, it's a 3-2 council, they can change the definition because they don't like the two people in the minority. And so you want to have it in the charter, a term that's defining.
So legally they could, practically it's probably not a good idea.
That's a little stronger than what I meant to say. It's like, it's hypothetically, I haven't researched it.
Okay.
It's hypothetically permissible. But as for when this comes up in the future, you'd like to be able to look to the charter to find out what the definition of, ceases to be a resident means for the section in the charter.
And then for the newer members, one of the things we had looked at, the possibilities for further defining residency might be to refer to some state law, electoral law, or other state laws that it's prescribed in different areas. None of those definitions necessarily match up. And you get domicile that gets thrown in there too. It gets muddier the further you go.
Well, I don't think it does get muddier because the whole idea of having an elected official that represents you at city government is the idea that you can express yourself to that person and get your quality of life issues and other things to their ears. And if you have people who are, I'm just going to pick on transients tonight, are transient and are not available to people. They're not doing their job as a representative of people, either whether they're individuals, a block of people, or a whole district.
And again, that's really up to the
The funny thing
voters.
is, in today's world, that transient could have a cell phone, could end up going to the public library to access email. They could be incredibly accessible. They've got all day.
Well, and if I may, it's two things. Remember, I passed out that article that was timely of the elected official up north.
Yeah, but
who
she's a bullshit artist. I mean, let's cut to the chase on that one.
Who
I
was
mean, that
homeless.
is, you were talking about the lady in Ojai.
Yeah.
She just doesn't want it. She just wants what she wants. I mean, I don't know if you've been following. You gave me the article. You piqued my interest, and I went after it. Okay, so let's not, don't bring up people who are red herrings unless we're going to have them. Yeah, they are. She's a red herring.
How is it a red herring?
Because she's saying that she's being kicked out of her house and she can't find another residence. Well, okay, why doesn't she pitch a tent? If the solution is you can pitch a tent and live under a tree, why doesn't she do that? No, it's just bullshit. It's plain out bullshit.
I'm not, To the
You pushed
state,
the button.
I'm
You pushed the
attesting
button.
to her.
You pushed the button. You
I'm
gave
not
me the article. I read the article. I researched the lady, and then now you're gonna rely upon that.
I'm not attesting to her character. I'm
Brought her
saying,
up, you brought her up as evidence.
no, I'm saying that's an
As
issue
reference.
that other councils have to.
Okay, it's
Mr.
reference
Morocco,
now.
Mr.
Okay, good.
Morocco.
Okay, to go to Chair Spritzenberg's comment, the way it is set up now, the city council is the one who ultimately decides if the person should be kicked off for not being a resident. They're the ones who are deciding what the word resident means in the context. And I think that's kind of what you're going to. As I mentioned to Mr. Dweziak, putting somebody in, it's a pretty clear definition other than resident for 30 days, but you can get that resolved before an election. But there's even some state law that uses the word inhabitant, which goes to the person who camps out in a tent, or somebody, in the case in Ojai, I believe, got evicted from her place, and there may not be. And District 4, when we talk about 2-year rules, that's a lot of people that are tenants. And I think tenants have a very important place in our city government, because we're, I think, over 70% renters in the community.
We're just over 50.
It was a high number. I just remember that.
51%.
So putting that extra period of time, it kind of restricts some of those people to areas where if they want to invest on a house, they are limited with that. But I think that we have the word resident. What I think is abusive is if the council kind of changes it all the time. And I think that we should have a process in the whole thing where the city clerk can verify and get asked, and I've told this to Mr. Webb, attestations from people on a periodic basis, kind of like they do with the financial disclosure, and ultimately verify that they are residents. And if it turns out that they're not, ultimately it brings in the criminal process for fraud on the city. And I think that's one of the things that does come up, is somebody saying that you're getting compensated when you're really not a resident and you shouldn't be on there. So,
Or you're not qualified.
yeah. So again, my focus is on the kicking them out part of it. I think we've got it covered, and nobody's ever said that we've had a problem on the eligibility side to be elected to the office. It's once you get there, that's the part that we need to focus on.
If I could go back a second to the requirement that somebody is a resident of the district that they're running for, and it seemed to be the opinion that there was no requirement that you had to be a resident of the district that you're running
No,
for.
the question I was asked was whether there's a state requirement. There's not a state requirement for a city race. In our charter, for example, section 6.5, and this is, again, we're talking the context of when does someone vacate their right to be in office, and if it's, they miss 4 or more meetings without permission, convicted of crime of moral turpitude, or ceases to be a resident of the district from which such council member was elected. The problem is, we don't have a definition of resident, and when you look at other definitions in state law for clarity, they all conflict with each other in one way or the other. And because holding office is a fundamental right, tie definitely goes to the office holder.
It's a fundamental right if you're qualified.
And again,
Fundamental right if you're qualified. You can't be president of the United States if you're not 35 years of age.
I agree. But if it's, because it's a fundamental right, if there's a question,
I
tie
couldn't
has
agree
to
more.
go to,
I couldn't agree more.
you know, if the ball, if you beat the ball to the base, you're safe. If the ball beats you, you're out. But if it's a
Tie
tie,
goes to the runner.
if it's tie goes to
Okay.
the runner. Tie
So, I
goes to
mean-
the office holder.
But that's why we have video cameras. So, I mean,
It's funny, the school district makes the determination whether someone's a resident or not all the time.
I don't know what.
The school district makes a determination whether a student is a resident or not. They'll even knock on your door at 6 a.m. to see if the kid actually lives there, or if they're just using their grandparents' address to get eligibility for Redondo Beach schools. I've seen people use storage buildings as addresses to qualify to be in a Redondo Beach school. So it's just kind of interesting. They seem to be able to navigate what's a resident and what's not.
But I think I started this with, I'm for residency requirements, and I'm for people who have a stake in our community, whatever that means, okay?
That's the
And we can argue this out, what we're gonna recommend to the city council. But we do have to have, another one of my overused phrases, guardrails. We need to have qualifications so that we don't get people who basically stock the pond. How's that? Come in, and we're gonna have a crucial election, let's say a mall by the sea. And so, people come in and, where the Elks Club said, just the side of the Elks Club, where Torrance Boulevard is now, there was once a tent city there. And people came down, they rented tents. So what's, and City of LA and I think City of Gardena are both dealing with, I'll just say, pop-up RV parks, okay? What's to prevent that in a crucial election, people coming in and re-registering in Redondo and just saying, okay, I'm here, I've been here for, I'm a qualified elector and for 30 days.
Well, I guess the answer to that is there's nothing. There's nothing in the current
So-
election code
Well, I got that part.
above and beyond what we want to put in the charter.
But it will affect the residency, the people that have residency here now, that's the 72,000 people who are here now, lifestyle and their quality of life. So why do you leave open a door for something as important as quality of life, whatever that means, to some nebulous term as a residency? In other words,
I don't disagree with you,
Okay.
but so define it.
well, again, we can debate that.
I just want to hear the debate. I don't even know where the starting point is. I mean, yes, you're right. You could have a starting point to get crazy. You got own property in Redondo Beach.
No, you don't have to own property.
No, I'm just saying
Okay,
that
I
that's a
realize
starting point. I'm
Oh, you
not-
want to debate? I was ready to jump in.
You register to vote, that's the first one. That seems
Sure,
to be
but we-
unanimous.
That's not residency. That's you have to
I
be
know, but
qualified elector.
that's the starting
separate-
point that's got
That's the
common
lowest,
ground.
that's the lowest bar. I think
Right.
we all agree
And
with that.
then we go to the extreme, and I love the gray areas, an inhabitant. Does that mean that you would be eligible to stay in if you're an inhabitant of the district that you're in? And that would bring in homeless people, people in camps, people on park benches, people in their offices because they don't have a home, people with post office boxes.
We have an example though. I mean, we have the small houses up in the north, in the District 4. So we have all those all those people are technically residents, right?
It depends on where.
And they only have, what, a 30-day span? They'll stay there? How long can they stay there? Forever?
No, it's not forever. It's ideally up to 6 months.
Trying to give you a softball here.
Yes, but it's nuanced, so I can't. So ideally, they can stay up to 6 months. Most of them are moved on to permanent housing before that. But they could, if they intend to. I love Redondo. This is where I'm staying. My residence is here. A homeless person, a person experiencing homelessness can change residence today and change it again.
So right.
Tomorrow.
That part, that right, I'll give them. That's.
Well, but do you think that it's a danger? Because we're only talking about removing, we're not talking about the right to vote because we can't control that. Is there a danger that a RV encampment would be set up 30 days before the election such that they would actually win an election?
You know, once upon a time, I worked in the intelligence field. And when you brought up a possible scenario of a threat, I heard maybe 10, 15 times, nobody would ever fly an airplane into a building and cause mass destruction, okay? That was prior to 9/11. After 9/11, we don't talk about that anymore, okay? Same scenario, okay? You just apply the facts, you can apply your soldiers any way you want there.
Japanese kamikaze pilots excluded.
Well, I don't think they do that anymore. The Japanese
though.
came to their sense.
Okay.
Well, no, that was desperation moves.
So with regard to residency, do you believe that the mayor should be a resident of the city?
I do.
Okay, that is not prescribed in the city charter.
Okay, so as you guys are fond of saying, we need to fix that.
Okay,
Okay, so I'm.
with that one. Because that's one of the ones we had talked about, that we've got this discrepancy
I got it.
amongst the different offices. For the offices of city clerk, city treasurer, and city attorney, it is also different from city council. City council is the only one that alludes to residency, maintaining residency.
I am in favor of everybody living in the city that represents the
So
city.
maintaining residency, whatever that means, would be verbiage we'd want
You
for.
used maintaining residency. I said lives in the city.
Okay,
Words mean things.
understood.
And it's 8.1 that you're looking at for the mayor.
Right, the mayor only is required to be a resident to file, to run for office.
Okay,
And in fact, the way it's
so
written,
maybe that needs to be wordsmithed a little. That's not really,
and the way it's written, they don't even have to be a resident at the time they're running. They only need 30 days prior to.
please, again, you already know my opinion on 30 days.
Understood, but I'm just clarifying where we're at right now, and that we've talked about, yeah, should we, and I used the word cleanup. I'm going to use it again, because I do think it is clean. I don't think this was intentional necessarily to have those discrepancies.
Different time, different place.
Different time, different places maybe.
And that's the problem we have with moral turpitude. Society judges what moral turpitude is, and it's a moving target. Things that are accepted today were never accepted in 1947.
Yeah, so the city council is the only one that defines or ceases to be a resident of the district from which he was elected. It's, or ceases to be a resident is only prescribed for city council members currently.
Okay, I'm willing to add it in for everybody.
But residency in general, because when we move this to talk about city attorney, treasurer, or clerk or mayor, it's not district anymore because they are at large.
Citywide.
Like the school
But
board.
would we, like the school board, would we want that similar language that you want these elected officials to
Reside within,
maintain residency? Because that's the opposite of ceasing to be, it's prescribed as if they cease to be a resident for the city council only.
you could basically solve that by putting in like a preamble that all, the basic qualification to hold any elected office in the city of Redondo is to live within the political boundaries that you represent.
So you're saying live, which is an inhabitant standard, so you're bringing in the homeless that you were saying.
I'm not choosing to exclude them on that level.
Okay, I was just,
Clearly, we have homeless people living here. I mean, the real question is, are they qualified to hold office? If they can prove that they meet the qualifications, I'm all for it.
And the other aspect of the current verbiage, even for city council, it just says, or ceases to be a resident of the districts from which he was elected. We've changed that to they.
Again,
But there's no time prescribed to that.
I personally think you can solve that all with like a preamble sentence that covers everything that you want. You must live within the political boundaries of the subdivision that you want to represent.
I'm not sure where we
Wordsmith that
would
any
put-
way you want, as
I
long as.
don't disagree with what you're saying. I'm not sure where we would put it under the current organization of the
Put
charter.
that as the first qualification.
But the sections are different. We'd have to do it for each section.
Okay,
There is, Article 6 is city council. Article 8 is mayor. We don't have an overall,
so why can't we put in a 6A or something like that?
we could, but
The
we'd have to also do it in 8 and 10.
Okay?
So that, there's not one place to put it.
You can put it in
And,
five.
we're in the electronic age and we're not printing paper anymore. It just, that doesn't matter. If you want to put the words down.
Okay.
If somebody's going to argue with them, that's inevitable. You're not going to get away from that. The real question is, do you have the stomach to argue back?
So it doesn't need to be in a preamble, it just needs to be within each of those sections.
Okay, if that's what you wanted, like I said.
Okay, so that's where we were at with one aspect of residency was, the two key aspects were, is there a further definition that we would recommend placing to make it less subjective by city council in making a determination?
This is for removal now, or are we back to removal, or are we on for election?
This would be more for removal, because
Well,
It would apply
I consider
to-
the removal a separate issue from qualified to hold office.
it would apply the same way to being.
Well, it doesn't apply.
eligible.
It does, but it accomplishes the same thing, but it doesn't.
What accomplishes the same thing but doesn't?
By saying we're doing, if you lack one thing, then you're disqualified. You're not qualified any longer. No. Again, if you're qualified to hold office and you get elected by the people, you're elected. Circumstances change, and I'll go back to what I said before. Whatever that may be, you want a removal process. So I'm guessing I think that you should probably put in a cleaner section that has to do with public officials being removed from office. And you apply it across the board. So there's no unequal treatment. I mean, there's nothing in there right now if somebody has a stroke. You want to put that in there?
It is in there now.
Oh, really? It's a physical incapacitation? What did I miss?
There's a specific example.
Having suffered a stroke,
I know that.
there's a provision,
Clause.
yeah. So the council shall grant 6 months of
Handle it the same
medical
way.
leave. Yeah, the positions do have different standards, but they're for a reason. So for the council, the most important, one council member doesn't have any power. They have power once they band together in a group of 3 or more. So with them, the most important thing is showing up to city council meetings. And so they're vacant, aside from moral turpitude or residency, if they miss 4 meetings without being excused by the rest of the council. City clerk, city treasurer, city attorney, they can't leave the city for more than 30 days because they have things that can't wait for more than 30 days. And so they have different standards. So, residency, I think, should be the same. Moral turpitude should be the same. It's up to the committee whether or not, I don't know that one size fits all for the very different jobs.
Again, would not, I'll just say, someone who held an arbitrary view have grounds to sue over that? In other words, if you treat one elected office different than another elected office, regardless of the reason, you went through the 30 days and having to make decisions and all that stuff, regardless of that, you are treating them differently.
But the qualifications are different. And that's
Now
tailored
we're
to,
back to education and duties of the office.
right, and that's why you can
Okay.
treat if you just arbitrarily pass a vacancy that you couldn't justify then yeah, you deserve to lose. But if you can tie it,
You don't know how subjective that sounds, I just like to understand.
well,
It's a very subjective.
well, no, you have a problem if the clerk doesn't file or do anything for for more than a month, especially in the old days. It may be modernized because of the, Zoom and Microsoft Teams. You'd have a problem if the city attorney couldn't respond to lawsuits or sign contracts or approve as to form resolutions and ordinances. And so there's a reason that the clerk, the treasurer, and, well, the clerk and the city attorney, full-time's job, treasurer in the past when it was full-time as well, you would want to have a more exacting standard. My vacation plans would be much easier if it just said I couldn't miss 4 in a row without council approval. But I don't think that should necessarily be what's in there.
And that's why you waited till your kids were all grown to run for office.
Oh, no, my kids were not all grown when I ran.
I know they weren't all out of the house.
Okay, let's bring this back to some actual.
21.4 is the place where you would be putting it. Right after the oath of office, unfortunately be right after adult entertainment and sex-oriented business, but that's where the miscellaneous provisions would go. That would cover everything if you needed.
Okay, first of all, does anyone disagree with the aspect of leaving moral turpitude as is and not attempting to make any further definition? Does anyone disagree with that? Okay. With aspect of the 30-day requirement, is there anyone that would like to forward the idea of increasing or changing that in any way?
6 months or a year.
Okay, is there anyone else?
I agree that it should be longer than 30 days. I don't know what it should be, but 30 days sounds very short for someone to become acquainted with the area, know what they're doing, know the clientele, and 30 days just seems too brief. But I don't know whether a year is.
Eleanor, when the elections are announced and open to people to actually file their statements of intent to run, what's the time period usually between that date and the date of the actual election?
December to March.
So, let's see, 88 days is when before we call the election, so that's when nominations start. And so I think it's 4 weeks, 4.5 weeks.
Okay, so I'm fine with 88 days from the date that you can actually file your papers, you're eligible to file your papers. That's when you should at least start your residency.
Would you accept 90?
I'd accept 90.
I'd accept 90.
I
But
think
it's
at least
90
you have a common basis that would be
Okay.
reasonable under the law.
Okay, I got it.
But
Although our
point of
city attorney doesn't-
clarification, 90 days before accepting the nomination papers or 90 days before the election?
So it's, if I remember correctly, it's
90
30
days
days.
before filing.
Right.
So if you add 90 days, you're making it 6 months before the actual election.
Filing or appointment.
Right. I just wanted to clarify what we were talking about. So we're talking about 90 days before filing nomination papers. I'm still okay with that, but I just wanted to be clear what we were actually talking about.
And that is the current language. There hadn't been any
Yes.
indication to change that aspect of the language, that it was
Which part?
the days prior to such filing or appointment.
Well,
It's 30 days
No.
right now.
So
no, but that's part of the election process. We're talking about residency requirements to run for office. I mean, it's.
That's what I'm talking about.
Two different things.
No, that's what I'm talking about.
Okay.
Is because to run for office, you have to file.
I got it.
To be appointed, you're essentially
Like I
running
said,
for office in a different way, but
I could live with 90, I wouldn't argue against it. I would live with 6 months. I would cheer for a year, but it's different. I mean, so, I'm a part of a compromise here,
and leaving it as
hard as that is for anybody up here to believe. I know you're laughing.
just to change it 90 days immediately preceding the date of such filing or appointment. Just change the number, not the prescription.
No, I was actually looking at when you open the election up for people to file papers, that's when they have to at least state their intent to become a resident.
Well, they have to, yeah, I
be a
guess, yeah,
resident.
you'd have to be registered to do that, though.
Right. So that somebody doesn't look at the actual, oh gee, no, nobody's running for office 30 days before, let me just submit my own papers on it. When Eleanor or whoever's the city clerk opens the time period, that's when they have to either say, I am a resident or I intend to be a resident in this district.
Well,
That opening date, does it vary?
Whoa, wait, a minute. Can I?
The opening
The
day,
intent to-
it's the same time,
I'm a
I mean, it's, the day is different each time, but it's still 88 days. And then,
You open it 88 days prior to the election.
correct,
When do you close it?
it's like 4 to 5 weeks after that 88 days. So, and then when they come in is when they sign the affidavit that says they've been a resident for 30 days.
Can you give us the dates from the last election or reason, just ballpark it?
Let's see.
Meaning,
So it
Like
starts
December the 4th?
So it starts the second week of November. It's
Okay.
right after a November elections, the next week. Then it ends like December 13th or December 8th or 9th, right around there. Because if someone's not running, then you have to extend it
right?
for another 5 days.
And that's ours, or is that election, is that in our charter?
That's the election code.
That's election code, okay.
Correct.
Just wanted to clarify that, that's what I thought.
The dates are the election code.
Okay, so
So what we're actually talking about here is where the 90 days starts. Is that correct?
that is.
Working backwards.
We have two aspects here. We're talking about the number of days, period, and then from which day or description of day does that 90 days begin? Currently is written as immediately preceding the date of such filing or appointment. So the day they file is up to them within that window. But they have to be currently 30 days before whatever that day is.
File.
It could be at the very beginning of the period, it could be at the last day of the period. But they have to be 30 days before that specific, it's event driven, that's what I want to say, it's,
I got it.
it is
I
a
understand.
specific event.
See,
So do we want to leave
Yeah,
that, you're
I would,
saying,
if
no?
it's event driven, if it was event driven, I would have it in my perfect world. It would be 90 days before, from the day of the filing, prior to the filing period opening. So if you want to file your papers on the first day, you can do that. If you want to file on the last day, you can do that. But the event trigger is going to be the first day
The filing
of the filing.
opportunity opens, the
That's
window, I don't know, what, is there a name for that?
Nomination period? I mean,
Okay, now the beginning of the very first day of the nomination period,
Let's just say the first day
as
is,
announced by the city, because that does get announced, correct?
Right. So technically, they pull papers and then they come back. Remember, they have to go out and get nominations.
again, whatever they have to do,
Right.
the qualification, in my mind, is going to be 90 days prior to the first day they can give you their nomination papers.
They give it to her or they're allowed to give it?
Allowed to give it.
That's a difference.
I agree.
That's a 4 to 5 week
I
window, you
misstepped.
said, roughly? So that's a 30-day roughly difference right there, so. And I
No, it's
just
not,
wanted to
there's no
clarify.
difference if the rule is the day that you're eligible.
I understand. I
There's no, because everything after it is, open territory.
So your position is that event should be the day the nomination filing period is first available,
That's
opened.
Prior.
I'm sorry, say that again.
Be a resident.
90 days prior to.
That's
Prior
right.
to, but that event would not be their actual filing or appointment, it would be, so what do we do with appointment?
Appointment what?
Well, we got to address appointment too, because appointment's in here.
It's a whole different discussion, I think.
Right now, they're co-joined.
Okay, so
I would actually suggest.
So 90
and again,
days.
In trying to deal with the lawsuit that will come up undoubtedly because this deals with restricting people's rights to elected office, I would go with 90 days prior to the election, which is a more fixed date and firm date that people can understand, and keeping the theme 90 days prior to the appointment.
But we open the period more than 90 days prior, don't we?
88.
88.
88,
When it opens.
that's when it opens.
So it's not, it is 88 always?
Sorry, I'm sorry. That's not 88, it's more than 88 days.
That's what I thought.
Yeah, because December, the first week of December is during the 88
Excuse
day.
me.
So it's actually, what is it, about another 35 days? So it's the middle, it's the. middle of
Prior to
November.
that. Yeah.
So it's more than
When
90.
the period opens.
Correct.
Well, that being said, so I think we also have a practical matter here in the respect that we're all throwing darts at a dartboard
Nothing.
to come up with consensus on the number of days. The voters are going to be looking at this, and the more you change, especially when you start changing language, in my opinion, it's going to make it harder for people to go along with this. The simplest thing to do is to change nothing but the number. Because from a voter perspective, when they look at the proposed charter amendment change, it's the easiest for them to understand. All you're changing is the 30 days to whatever days you decide to come up with. But the second you start trying to change anything else about it, you are creating, you run the risk of losing voters positively going along with this change. The cleanest thing is just change the number.
I agree.
Ron?
That being said,
I just want to hear.
Sounds
what
to
the
me
city attorney
then-
has to say. He's been shaking his head no during a couple of things, and
He's been shaking his head no behind my back.
What's the legal aspects here that we should,
Or the risks.
let's start with 90 days. Is 90 days, it does become more challengeable than 30.
Right. So what I was going to ask is, do you want me to research that? Because before the committee had coalesced, it's not worth it. And we talked about, there are some definite guidelines, and we talked about the Supreme Court case regarding, out of California, regarding welfare benefits, where you couldn't tie it to being, it was a law that said for the first, and I forget how long, let's say the first year, you could only get the level of benefits that you were entitled. If you moved to Wisconsin, you could only get the level of benefit because that Wisconsin offered, because they were concerned people were moving here because of the higher benefits. And the Supreme Court said you can't do that. You can't time base a benefit that's provided to a resident. You can decide whether someone is truly a resident or a fake resident. But if they're a bona fide resident, you can't do that. Now, clearly, some time limits are okay. If you want, you didn't before, but if you want, I can look at 90 days and see if there's anything that will shed more light on it.
I would go for that, but I would also say that being elected to any office that represents it is a privilege and not necessarily falling into, I'll say, health and welfare. I mean, health and welfare is what, in my mind, is separated by miles. Okay, so, I mean, we have a border and we have all kinds of people who we're feeding and housing and doing all kinds of things for. We're spending tons of money on homeless people. That's a completely different genre than people who run for office, make decisions about how money is spent, how infrastructure is improved. I mean, there's a whole series of things.
Understood.
Two different things.
Understood.
Well, I got to make the point.
So I can look at 90 days. I can look at 90 days to a year. It is still a fundamental right.
To run for office.
And to
There's
hold
there's
office.
no prohibition in running to office because of 90 days.
I don't know. And that's, so
Okay.
I'll look at, if
That's-
I can find examples that 90 days okay and hasn't been challenged, or, a year is too long and has been
and-
challenged, then it will give you.
What we do have,
Guidelines.
I believe, is a plethora of 30 days existing now
Correct.
and well accepted.
And that's, I think, why
Oh,
the
aren't we gonna take
committee
Bob
had
Hensler
decided
approach?
not,
Everybody else is doing it. I mean, is that what we're doing with this?
hold that thought.
I will.
But did Bob research all this stuff
No,
to see
no.
which,
No,
what
he-
the different jurisdictions?
He's always in for, you know, everybody else is doing it, so.
I thought that Bob had looked at the days and I thought he
I don't
came
think
up
he
with something.
specifically looked at days. He may have. I don't remember that he did.
Yeah, I don't think so. I think
I
that
know
was
from
on,
reading things, 30 days shows up a lot.
right. And I think,
It's a committee.
yeah, I
It's a safe number. I'm
At
sorry.
your first meeting that we talked about it, I gave a list of most of the charters that dealing with eligibility and remover, and then I think Bob supplemented that for the next meeting.
Is there a general law equivalent
I'd have to look. I don't know
for a general
offhand.
law city? Because that's a good one to compare to.
Yep.
That if it's reasonable for a general law, certainly it's going to be reasonable for a charter. If we go more than what general law may or may not allow, then we would be subjecting
When you say
ourselves to
reasonable, you
risk.
mean latitude.
Latitude is yes, I would agree with that.
I had another question for Eleanor.
Sure.
In order to vote in an election, do you have to register by a certain date? I seem to recall you could even do.
15 days before,
What?
15 days before the election.
But I thought you could register actually at election
Yeah,
sites.
I thought you could just walk in and register.
You can do that at the county, but it has to be, it's those who have become, became a citizen, they can vote on that day. I think that's how it works. You know,
I thought that you could register and get an additional ballot on election
on
day.
election, no.
I'm sorry?
No.
I'm gonna have to take your word.
Because I know we've
I'm gonna have to dig
asked.
up an article.
Yeah. I mean, I can double check for you.
Okay. No, you don't have to do that, but I take your word for it.
Okay, what's the high end that we would like to request our city attorney to look into?
The city attorney said he would do 90 days to a year.
But that's what he said.
And I'm in favor of that research.
I'm asking the committee, not
Okay,
just,
well, hold on. I'm
is there
registering my opinion.
anyone that would like to go greater than that for any reason?
Greater than,
Than 1 year. Because currently, we've talked about initially 90 days, and we open it up to a year that the city attorney would research for comparable applications, I guess is the best we're going to get.
Application,
Okay.
applicability.
What I would think that would be helpful is not what the other cities do, but where there have been legal challenges to the dates. And I think that's
what he's gonna do.
something that our city attorney is going to do. But I would be interested to see where it's been challenged. And I actually, since it's dealing with elections, we may have to go outside of California to see if there's anything more specific that has raised the issue as far as not being something that's allowed.
Okay, so are we good with up to a year?
sure.
Yeah. Right.
So, Mr. City Attorney, is that acceptable to you? Understand that our request to look into expanding currently just the number itself, not the event.
Right.
And are we of consensus to leave the event as it's written currently, meaning immediately preceding the date of such filing or appointment?
I'm not on the consensus on that. I'd like to start with the number and then see if we need to look at the events. I assume that you need more than our next meeting to do this research?
No, I shouldn't.
He's doing it right now.
Oh, okay. I think we can, when we revisit the number, I think we can revisit the event.
Okay, is there anyone else that would like to look at the event? I would be of the mind to keep the event as is.
I agree.
I'm happy with that.
I believe we have a consensus to not look at the event.
It's the par for the course,
Your input
right?
is noted, yeah. Okay, so that was the discussion on the time aspect. Now we have the application, meaning do we want it to be universal for all offices as it currently is for the city council, that you have to maintain residency? That's not the way it's written, but that's the aspect of it.
Is that a question?
City council is the only elected office currently that has the stipulation that or ceases to be a resident of the district from which he was elected. There is, no other office has a stipulation that ceases to be a resident of the city.
I'm not speaking for the writers, but I'm just going to say they kind of assumed that the people who held the other offices were residents. I mean, I don't, that's,
I wouldn't even go that far. I would say it was probably done at different times and just.
yes, different time of different places.
So.
I agree.
do
Certainly
we
a less,
want- do-
certainly a less litigious.
Do we want our mayor, city clerk, city treasurer, and city attorney to maintain residency within the city during their term of office?
Yes.
Okay. That would constitute changing the charter.
No. I'm in favor of that.
I agree.
Yeah.
To make it more universal,
Yes.
equal.
Yeah, I would agree with that.
Okay. And we would work that into the language of each applicable section, because that's how it's divvied up right now. Okay, so that aspect I think we're agreed upon. And then it comes back to the third concept regarding residency, which was the definition itself. I'm not hearing an inclination to somehow further define residency within the charter. By the committee. I understand you
No,
definitely.
I think you put the word in residency. If you want to define residency, I have no problem with that. But I think that really does, in other words, if somebody wants to live in a tent, that's fine. If they want to live in, a mansion, that's fine. So that's not really the issue to me. In other words,
We
as long
use,
as you're an inhabitant, and the people elect you,
but it doesn't.
and you're qualified.
It just says resident, and that's what we talked about. Do we need a further definition to that word?
I don't know how you do it.
What
Well,
about,
I think, I'm sorry, Jerry, go ahead.
But the referral from city
We don't
council
hear from you
was
so
to
often.
look into,
Speak up.
would there be a,
Hey, Jerry wants to talk. Mike.
go ahead, can I have the floor, please?
What do you do with someone who is elected to a position? He has a second home in Palm Springs, and he's back and forth between those two. Does the current wording cover that and allow that?
It is for the other offices that don't have the stipulation to maintain or to, this says ceases to be a resident, and it doesn't have any time frame to that. It just says
Well,
ceases.
can
I finish, please?
a question down there.
We'll come to that. But first question first, and then the other ones talk about 30 days, consecutive days, does not perform their duties, or consecutive days without permission, absent himself from the city. And that's without permission of the city council. So there is a prescription in those other offices. Now your question.
I was going to propose that I think clarification for residents, I might like to see primary residents.
How about where you're registered to vote?
People are registered to vote all over the place. That doesn't mean
Well,
it's
not
their
twice, they're
primary
not.
residence.
On this, that's supposedly in this state anyway. So you can either be registered in Redondo, or you can be registered in Palm Springs, but you can't be registered to vote in both places. Municipal, you could probably get away with it if nobody checks the voter rolls, because two different counties, but technically it's illegal.
So.
Wait, Madam Clerk, is that true? Did I speak the truth there? Okay.
I don't disagree with the idea of adding primary. However, then how is primary residence defined? We don't have an absolute definition for that. It's, in essence, it's subjective, yeah.
But again, I I think if you make a requirement that they be an elector, they'll be registered to vote at an address in Redondo, that covers that qualification.
I kind of agree that the person is making the determination of what their
Right.
primary residence is
Exactly.
by where they decide to register to vote.
Where they're, I'll just use this, my phrase, primary allegiances. So you're voting for the
We're
quality of
not
life.
putting a primary allegiance into the charter.
Well, I didn't say that. I didn't ask you.
So-
I'm saying you could clear it up by making them be qualified electors. And a qualified elector is somebody that's registered to vote.
And the registration, being a registered voter does not have a preceding time requirement.
But we do have another section that says you do have that. We just discussed that for an
For
hour.
residency, but not for registered to vote. Two different things.
Many
What he's
people,
saying
there
is
are,
that you could
there,
change your
I
registration to
agree, but
vote
I
5 days
agree,
before.
but, you know, there are some people, prominent people, who you would think were civic-minded and voted all the time, who don't vote at all. And I'm not gonna, throw some names around.
Okay, I'm just going back to the charter, which is what we're focused on here, that there is not a prescription of, it requires to be, person shall be registered voter of the city of Redondo Beach at the time of filing his or her nomination papers.
Well, that begs the question then, could you change that and say, be a registered voter in the city of Redondo Beach at least 90 days prior to filing your nomination papers?
It goes back to the same question. We'll look at that.
Yeah, okay, I understand. Then it is the same question.
I don't know. It's the same question. So you weren't here before. The committee, looked at that 30 days is the norm.
For residency, but now we're talking about being registered to vote.
Right. And so we don't have a requirement that they stay as a registered to vote. So I can look at it, but I don't want to opine. Anything you go beyond may cause concerns that you're infringing on someone's right to hold office. And that's a fundamental right. But you have to tell me what to look at. The one thing I would say, we passed out a lot of materials from and it was a while ago, of all the different code sections regarding residency. And we had many charters with the removal language. It might be good rather than just talking, off the top of your head to say, I like these, I like this one, I like this definition because it incorporates the vehicle code, the election code section for being an elector. And that may be helpful. And then I can look at those questions of if you extend how long you have to be a registered voter, how long you have to be a resident, and see if going beyond the 30 days is more risk than the possible benefit.
Is registered voter different from elector?
That I don't know.
I'm going to answer my own question. It's problematic if you sit there and say has to be a registered voter any X number of days before nomination. We had the situation with Julian Stern where he ran for office in District 4 and he turned 18 before the date of the election, but he was 17 at the time he submitted his nomination papers. So to sit there and say that you have to be.
That's a good point.
Yeah, and I researched that and I just don't, recall what it was that I found, but there was no question that he was entitled to run. He was going to be 18 by the time he took office if he had won that election.
And then he also had, the county had provided a document that he had actually registered to vote because now you can register to vote at
that was it.
16, but it doesn't kick in until you're 18. So that was the other,
That was it. I
Yeah.
forgot.
I
There's
remember.
always going to be a twist and turn.
Yes,
So under ours, they don't have to be 18.
Well.
He wasn't eligible to vote, but he was registered.
right.
And ours says, shall be a registered voter.
And the state had accepted his
But does that
registration.
does being registered to vote make you a registered voter?
You're not an eligible voter, so,
It doesn't say eligible.
yeah.
Well, my proposed language for that was U.S. citizen at or beyond the age of majority in the state of California. So that's how I would sell that.
Mr. Morocco.
So for the new people, I think what Mr. Webb was referring to was the blue folder item from our February 23rd meeting where he went through a number of the jurisdictions and a number of the code sections. And to answer your question, I like the San Diego model the best. And I would encourage, and I think that's on page 27 of the materials from that date, but I would encourage you to look at that.
And what is the San Diego model?
The San Diego model talks about residents and electors, and it also talks about what happens when somebody moves, but it covers the mayor, the city attorney, and this actual council talks about what happens if there's a death in the elected office. Talks about Board of Education too, so it's
And that's from which date? I'm sorry.
February 23rd, 2023. But it's been a while since I've read it, but I've highlighted it before and I've marked it up before. So if we're going to come back to this, that would be my recommendation. I also, when I ended up being charged with helping to write our proposal on it, I actually reached out to Councilman Ehrenheim to get his perspective on what he thought. And one of the things that he points out is he doesn't think the charter needs to be changed, but he emphasizes, and I've emphasized it before, his intent is probably the most important thing if you're dealing with residents. Where are you intending to make it your residence? And it's a subjective standard, but it's something that you can get affirmations on. So again, I'm going to go back to what I've proposed several times, is we need some sort of affirmation under penalty of perjury that says, I'm intending to make Redondo my residence, or to continue making Redondo my residence, and signing that and presenting it, whether it's quarterly, semi-annually, annually, but it would be submitted to the clerk.
Isn't there an old legal saying that intent is extremely difficult to prove?
Well, yeah, and committee member Morocco knows that that I disagree with that approach because perjury is the most unprosecuted crime, and you have a system already in place to deal specifically with residency questions with the appeal to the AG to have them look at, filing quo warranto. So I don't know that adding a criminal process on top of it, perjury is a straight felony, and probably the person will finish the term before any action takes place. So I think it would complicate and lengthen the process rather than.
See, that's why the removal process is so important.
Okay, let's go back to what we're actually going to do. Does this committee see moving ahead with adding a time requirement to being a registered voter other than just at the time of filing? Because that's all it prescribes right now, is to be a registered voter at the time of filing. It's different from residency, it's separate.
Isn't that what the attorney's going to be looking at?
Well, we talked about looking into residency, but I want to confirm, do we want him to look into the time, adding a time aspect to the registered voter caveat? Because they are separate and they are different. Or do we leave that as is?
would your research come across the same cases that would be dealing with that?
I can't say that it would. You know, if the committee wants to do it, I'll look at it. If the committee is doing it just to,
That's what I'm trying to get to.
you know,
That's why I'm trying to
I
get
have
to.
more
Is there-
than enough things to keep me busy.
Is there a committee?
I'd leave it alone. I think addressing the residency
Yeah.
time period is more than enough than to sit there and open up another can of worms. That really is just kind of duplicating what we're addressing with the residency time period. So
Okay. Member Young?
I agree.
Okay. Mr. Morocco?
I'm fine with that.
Okay. Mr. Woodham?
I agree.
Okay. So we will not be looking into adding a time frame
To be a registered voter.
of being a registered voter, other than as currently prescribed, that it says at the time of filing his or her nomination papers. When do we get the updated copies of the charter? I keep saying the old language.
We have it in process right now, so soon. I mean, it's already been updated on the online,
It
the actual book.
has, yeah, hard copies of,
Yeah.
because you had said you would get those for us.
Yep, but, you know, I have people now, so we'll get that done.
Just asking.
I know. I saw that on the list that I still need to accomplish, so you'll get it. I'll email it to you.
Okay, is there any inclination of this committee to look into the word elector rather than registered voter?
They're not the same?
We don't know.
I think we know.
That's,
I think I know. Somebody uses those two words in two separate sentences. I think I'll just say, yeah, they mean about the same thing.
would we like
I
that?
think I'm a common man, by the way,
Okay.
just so you know, Jerry.
So with that, there is no, I'm not hearing an indication that the committee would like to explore changing the current wording of registered voter to something different. Is that a fair statement?
Yeah.
That if, as you say, they're the same, it won't matter anyway. So if there's no indication of wanting to change that, there's nothing to look into. I'm trying to take things off of your plate, Mr. City Attorney.
Thank you.
Okay, so as it stands now, the thing that we've asked the city attorney to report back in with this matter is changing the 30 days of residency to 90 or even a year, to look at the viability of those two numbers in that range. And you may find in your exploration that 6 months is still reasonable according to certain case law or something, we don't know, but that would be that's the brackets that we're asking for. Is that, just to reconfirm that? And we are or are not looking at enhancing in any way the definition of resident or residency? Or do we leave it as is, it is subjective? Even to make it objective, there is different versions within different laws. The election law is different from, there was another, I remember like a 544 and something else, the different codes when laws we looked at. But so is there an inclination to explore further?
Well, earlier this evening, we discussed making it all the same across the board.
That's a different aspect. I'm just talking about the
Okay.
definition of residency. I've already said yes for making it equal across the different offices. That one has been resolved. Yes, we would like to do that. The final one we have here,
Residency will apply the same.
agreed, but and we've agreed to that.
Okay.
What I'm asking now is, do we want to attempt to further enhance the definition of resident or residency, because it is not a solid definition. There is nothing out there that says it is this, you must do this. There's different words stacked on top of different, domicile comes into play, things like that. Do we want to look
Well,
at that?
Let me ask you this question.
Yes.
if it's not a definite, what would be, I'll just say the opposite. What would be a non-resident? We have to know what that is before we can say what residency is.
I don't know that I could define, I couldn't define
Well, I'm
that.
asking,
Yeah.
you brought it up.
Yeah,
I mean,
no, and I don't know.
If we're gonna define residency, we have to know what a non-resident is.
Well, I define it as someone who's start with registered to vote in a different location, different city.
There you go.
So
Or a different political subdivision.
Sure,
Because, yeah. Okay.
But we don't have that definition right now.
I know, but we do have the requirement that they be a registered voter in the city of Redondo Beach, which I believe at that point makes the whole issue of residency rather moot because there are so many different varying definitions of what residency is.
Well, they don't have the obligation to remain registered to vote in Redondo. So for example, one of the things I keep referring to, it's in your packet, is the definition of residency in the election code. And it's section 349. And it uses the word domicile. And they say residence for voting purposes means a person's domicile. The domicile of a person is that place in which his or her habitation is fixed, wherein the person has the intention of remaining, and to which, whenever he or she is absent, the person has the intention of returning. At a given time, a person may only have one domicile.
Well, then I guess I'd take that definition.
Now, the section right after that in C goes on to say, the residence of a person is which that place where the person's habitation is fixed for some period of time, but wherein he or she does not have the intention of remaining. At a given time, the person may have more than one residence. And so I wouldn't necessarily refer to 349, but I'd use 349B, look at that, it's in your materials, but in the election code, and you may want to define, because they define residence for voting person means a person's domicile in section A, and then they define domicile in section B. You may just want to take that, not use domicile, but say residence for this purpose means, and then go into that place where, in which his or her habitation is fixed, wherein the person has the intention of remaining, and to which, whenever he or she is absent, the person had the intention of returning. And at a given time, a person may only have one residence. If you want to do that, you can. But you have a number of other sections. So I really would urge the committee to relook at all the different definitions, because I like how you phrased, do we want to define it further? It's not defined at all. You know, and that's the problem we face. Do you want to define it all, or do you want to just say, you know, we'll leave it up to the will of the council, but that's an absolute invitation to get sued if they assert that right and the person says, you know, it's vague and it doesn't mean what they say it meant.
Where in the 400 some odd pages are you reading from?
On page, let's see.
Which item, first of all?
To get the date correct.
So February
That's why you put the.
23rd, it's item
I-1 blue folder?
I-1, no, yeah, I-1 blue folder. Yep, that's it. And you'll see I have, and there's other stuff to look at because I have earlier a sampling of the AG opinions in terms of when it was sufficient to, there was enough evidence that they vacated the residence, that they granted permission to sue quo warranto, and some where they didn't. I think I did 2 of each, so you could get a sampling of what was enough information to the AG to let it go forward and which wasn't enough. And then I gave a sampling of charter eligibility provisions, and a long-winded way of answering your question, in the blue folder, that section, which is not the only section, is on
We found it.
Okay.
So I'm glad you keep on saying intent in there, but this is supposed to be a public process, and all the other charter stuff that I've been reading, there's actually been some public involvement as well. And it may make sense if we're going to the council in November, and then the last time I mentioned this, you guys said, well, we're the committee that does it, but maybe get a wider forum so that people will know we're talking about this issue, and getting some feedback from the council about the different options that we're looking on, rather than coming with one single option, come up with multiple things and get feedback again in a larger public setting so that we can get a much better sense of direction.
If I may, the problem is the public isn't going to care about this until they really care about this. And the one person we've had attending, we found permanent housing for, so he's no longer,
He's a very nice guy.
and he's in a very nice apartment. So we're happy about that. And I would say that your task is coming up with your recommendation, because it's only a recommendation. The council gets to,
They want.
tear it apart, do what they want. You can each attend and say, yeah, I was the dissenting view and I think it should be this. But really, it's not just passing it along, it's you saying what you recommend, because you're going to spend a lot more time than members of the public will, hopefully going through all those different sections. What do I like to pick out, either from state codes that I gave you or from the charter, sections? You like San Diego, and that's something that, your colleagues can review. But I think before you make a final decision, and I'll come back next month with the 30 days, or is it riskier if you go beyond 30 days? And then you can come back, and maybe if you each have, okay, here's what I'd like to see, and you can craft a recommendation. And then you'd still have, another meeting to refine that. But that may be the best approach.
So is there a committee desire to explore further residency definition, or to leave?
Define it for
As
you.
is.
There certainly is on my part, yeah.
Okay.
Define it.
I'm unclear
I-
on the exact definition of that, so I'd like that clarification, but I don't know whether I want to go further or not.
We'll never get to an exact definition, probably. It's just not going to be possible.
I want to read the election code, was it 349?
Yeah.
Because that eliminates basically homeless people, just the way you read it. You have to have an expectation to return to.
Yeah, I don't.
I'm
I don't think a
not
return.
against people. I'm just saying that people to run for office need to be qualified.
I don't think it eliminates unhoused people. There have been unhoused people.
I didn't say it did. Again.
Okay.
You meet the bar, you run. Okay, that's it. Okay.
Mr. Morocco?
I'm happy, since we're going to be looking at it again, to talk further about it. I'm not a big fan of that section. I actually like the one that's
Well, I have to.
1700. I think 50 is the one that I think actually is more appropriate.
Elections code?
Of
No, government code.
government code.
Okay.
Ms. Young? I know this is a lot to throw at you in one evening. Welcome to the committee.
Thanks. I'm okay exploring further.
Yeah, I think, sounds like we kind of boiled it down to two possible sets of language. I really like the idea of adopting something that's already in some government code, whether it's be the election code or some other government code. I think it gives it a little bit more legitimacy right off from the start, a little easier to sell. So yes, I'm fully in favor of exploring it further, but I would try to narrow it down to an existing definition that's already out there rather than trying to reinvent the wheel on it.
Base it upon
Yes.
somebody else's, right? Yeah, I agree with that, right? And come up with-
Well, he's talking about established law that
Right.
that's been out there and people can challenge, may have, or,
To use that as the basis.
right, yeah, right.
So if you look at the February 23rd agenda, look through attachments 2 through 7, because the first deals with moral turpitude. And that'll give you a memo from me, and it will give you 4 AG opinions, 2 where they felt there was enough to go forward with the trial that they'd vacate, and 2 where they didn't. And then you'll have a sampling of charter sections dealing with it, and you'll have a number of government code sections and 2 elections code sections. And you can drill down, which ones would you like to see or which parts would you like to see? And that may be most productive.
I think we can get there. Where would we put it? Would we,
I mean, in the charter.
in the charter? Do we
No.
distribute it under each section?
Under each section, each elected.
Make it a
position.
repetitive thing, but make it the same? Okay. So anywhere that, there's going to be basically 3 different sections because we have section 6 is city
You don't
councils.
think we could do like, well, there is a 10.3 already, so like a 10.2.1 or?
10 doesn't apply to city
Well,
council.
that's not what I meant is we can't put a section in that covers everybody?
You could, I would wait until you know what it is.
Oh,
but
yeah,
You could do it
oh, no,
either
no,
way. You could
yeah.
put it in each one, and the nice part is, if somebody's worried about, what does that mean? It'll be in each section. They may only be worried about one office, or you could put a catch-all for the purposes of, and then list these 3 sections, resident means this.
But
Either way,
where
either
would
one
we
is
put a
fine.
catch-all? Where would we put that?
Miscellaneous provisions.
Well, we could, I would wait till you have the language, and then we can discuss where you put it.
Okay, so that falls back to the committee to go back to review the materials we have now. We're not asking for anything new. We're simply charging ourselves to go back and look through the materials we have now that have been provided
Right.
to be able to come up with a consensus from that. We're not requesting any further investigation outside of what's already been provided. That agreed with everybody?
So I can move the table up to our next meeting?
Possibly. Yeah, I think we've covered the aspects here, so we are in definition of the moral turpitude, we've agreed to leave alone. The application, we've agreed to look at doing it equally throughout the different offices. And was that for both maintaining office and, yeah, maintaining office was the key one where it's not equally distributed right now. Okay, and you will follow up by the next meeting, Mr. City Attorney, with the aspect of the 90 days to a year, only
Yes.
with respect to residency,
Yep.
not with respect to becoming a registered, being a registered voter. We're
Yes.
going to leave that as is, that falls to at the time of application. At the time of filing. It does not talk about being a registered voter for appointment. So for example, when the city council appointed a replacement for District 1, when Councilmember Ginsburg stepped down, there was not, let me correct myself if I need to, for city council, is there a,
Has to be a resident 30 days prior to the
Registered to
appointment.
vote. Is there voter registration?
Residents.
I don't believe so.
I realize that, but he said resident, not elected.
I said resident?
He did.
Oh, yeah, well, we're talking about being registered to vote.
Wouldn't it be
Yeah, it's only talks about, it does, being registered to vote does not apply to being appointed, which is interesting. So you could be, it does say you have to be a resident, currently 30 days prior to appointment. For example, the city council makes that appointment, but you do not have to be a registered voter to be appointed to a
This is
position.
basically a ministerial or cleanup thing, so if you want to put that in there, I can make that motion. I mean, that's not a problem. In other words, if you think that we need to make them elected, and I think we should, I think they
Make
should,
them a
I
registered
think they
voter.
should be elected, you know,
Make that-
registered to vote.
that
As well as a
stipulation.
resident.
Yeah.
And the resident might be, if we decide 90 days, we might change the 30 days to 90 days.
Well, even the 30 days it will change it because they have to, mayor and council have to appoint a replacement within 30 days.
Okay.
So-
Well, no, I meant their selection, the person that they want to appoint or is nominated for appointment by whoever, would have to have the same requirements as to the person that got elected to the office.
And what I'm saying, it's not mere administerial because right now, the person could be a resident for more than 30 days, not ever have registered to vote, or, not moved here but never changed their registration to vote. If a city council position becomes vacant, they could get appointed and subsequently, register to vote so they can vote for themselves. Or not.
Or not.
If you change it to 30 days prior to appointment, then they're going to have to be registered at the time of the vacancy. Because if you put 30 days and the council has to fill it in 30 days, then that will be
I
a
fail to
problem.
see how that's a problem.
I'm
Yeah,
not saying it's a problem.
I don't think that's a problem.
I didn't say it was a problem. I just said, you said it was a.
I think you understand the point I'm making with this. There is no, to be appointed, you do not have to be a registered voter.
Right, and if you want to fix that, you should fix that.
I'd like to
And
fix
like I
that.
said, when I said ministerial, I meant the wordsmithing of the charter. So if he wants to put those words in, I'm all for it.
Yeah, that should be fixed.
It should be the same across the board,
Yeah.
whether you're elected or appointed.
Appointed. And I think it is a relatively easy fix to add or appointment as it does. So.
I think you should leave it to the council's discretion, though. I mean, you're doing that in a lot of other things. If they want somebody that they should
They're
be.
going to get a chop on this. They're going to get a chop on this.
No, I think he's talking about leave it to the council's discretion as to who
Not
they.
make it a requirement that they're a registered voter.
Yeah, and I'll make it a requirement. The council wants that as a criteria for the replacement. That person should be under the same set of rules for removal as opposed to the eligibility to run. So I think that the
Not
council could.
removal, but appointment.
Yeah, I know, but it's the same. In order to be eligible for the office, you have to meet certain requirements. So that's the removal standard as opposed to the election standard.
Well, here's my problem with not adding in requirement for voter registration. We get back to that residency issue. So we have a councilman member who resigns from office. Now, all of a sudden, we have a majority of council decides to appoint somebody who doesn't actually even live in the district, but decides, I'm going to declare my residency to be my neighbor's garage or somebody's garage. Maybe, somebody else elected official who actually lives in that district now makes them a roomie or whatever, and it's not reflective of their voter registration, but it's reflective, which I guess they can change. But suddenly you've had somebody who wasn't living in that district at all now decides to suddenly move into that district simply so that the council can appoint him to that position. I'm very leery of giving council that kind of playing around room. I think it should be the same as what it takes to run for office.
Absolutely. No doubt in my mind.
So to add the verbiage of, or appointment to the registered voter aspect as well as the residency.
Yes.
Yeah. Okay. I'll take a second to write this down in my notes or I will forget it. And the final aspect is there is no requirement to maintain registered voter status once you filed your papers.
Okay.
Should there be?
Yes.
Okay.
Yes, for the same reason.
Yes.
So maintain residency and maintain registered voter status.
Yes.
Okay, so add appointment to the language and add, Mr. City Attorney, legally, do we see any issue with adding a requirement that they maintain their registered voter status while they are in office?
I haven't researched it, but off the top of my head, I wouldn't think that's a concern, but I want to research it.
Okay, will you do that, please?
Yes.
Okay. City Attorney. Add, maintain.
Now, here's a question that came up with that last example that we had. It was an involuntary change of voter registration status. It wasn't a voluntary act on the part of the councilman that caused that whole kerfuffle to go. It was an involuntary act that was caused by the county recorder. So do you want to say something about voluntary versus involuntary?
It's a great point. I don't have a direct answer. It's an interesting aspect.
Well, I guess is there going to be a cure period? If it turns out it's involuntary, is there going to be a cure period? You're able to get that straightened out?
I think the county recorder is open 5 days a week, probably during business hours, 8 to 5. That's the cure period.
Yeah, but you don't necessarily know that your voter registration has changed on a pretty frequent basis. You'd have to be like checking every day in order to figure out. I mean,
Citing the recent example is what,
right.
and that's fair to do. That's a real thing.
So just hypothetically, if I don't check my voter registration every day and it's subject to change,
Rumor has it that happened to a whole bunch of people in Georgia a couple of years ago.
we're not in Georgia. That's
it
number one.
happened.
Number one, we're not in Georgia.
But it happened.
And we are dealing with Mr. Logan, so I got, your point is well taken. So, but I don't see that as an issue of, and I think it's an individual responsibility.
I don't know if my voter registration would change until it actually comes time for an election. When I say, oh, I didn't get my pamphlet or something like that, then I'd be on inquiry basis trying to figure out what was going on. But other than that.
But I think Mr. Morocco was correct that, in the true aspect of it, if we don't clarify something like that, the letter of the law says, if you're not a registered voter, if you don't maintain that, you're out.
Again, the people who hold office or are being considered for an appointment are held to a higher standard. And they need to check and maintain. They're not just average people. They're people seeking power. So, no, I'd leave it alone. If they're not qualified, they're not qualified. It's just that simple.
Leave it alone, meaning,
Meaning, I wouldn't give them any leeway.
Okay.
I mean,
put the aspect into the charter that we.
I would put it in there, you gotta be
Maintain-
you gotta be a registered voter.
And maintain that.
And maintain it, that's correct. So if you're worried about everything changing on you, then there's another book you should read. It's called, Only the Paranoid Survive. And that's another business book. But the concept really is your survival counts on your actions. So if you want to be an appointed person, you want to be a city council member, if you want to have power over other people, you had better maintain your P's and Q's. It's just that simple.
You're held to a higher standard.
Yeah, you're held to a higher standard. It's just that simple.
So here's a question to the city attorney / the rest of us. I think I read in one of the other cities' procedures for removing somebody from office, they used the phrase subject to judicial review. Do we have any language, A? And B, if we don't, is it automatically subject? In short, citing the previous example, if the council had removed him and he challenged, would he have the legal right to challenge it in court? I mean,
Yes. The council's decision is subject to challenge. Either they remove him and the council member can challenge, or in the event of the former city clerk, the council failed to remove him, the then city attorney appealed to the Attorney General for permission to sue quo rento, the opinion which I previously provide to the council.
I read it.
Okay, well, yeah, they should have removed him. The AG decided not to appoint at that time whether the council members could be prosecuted or removed for office for not removing him, but ultimately denied the request because there was such little time left in his
Term.
term.
So I guess I'm all for just leaving it the way it is, simply because if that situation comes up again or something similar to it, there is a redress. There is a judicial review possibility in the situation where a voter registration gets changed without somebody's knowledge or even permission, and they get removed from office because, according to the letter of the charter, they did not maintain their voter registration, then they've got the ability then to challenge it under due process and let the judge.
They also have the ability to cure it, as you said.
Yeah, but I don't know that the cure, so I'll ask that question then. Your city councilman does everything right, registered to vote in his district. Somehow, whatever, he buys a vacation home, and the next thing you know, the county registrar has suddenly changed his registration to his vacation home. He doesn't find out for 2 months, 3 months, pick a date. He gets challenged on it when somebody doing a check of the rolls finds it and demands that he be removed from office. He immediately goes down and gets it changed back. But according to the charter, he did not maintain his voter registration for a period of however many days he was not a registered voter in his district or whatever. Does he get removed anyway? In short, despite the fact that he corrected it, does he still get removed?
Right, and I would even throw in the aspect of
Well,
someone could
there are two things.
nefariously send in a card or fill something out and change and, falsify a signature.
So I guess to answer my own question, I would think that if somebody tried to remove him, well, let's just say the council didn't like him, removed him, that under judicial review, he would end up getting his seat back, I would think, but.
Doesn't it make more sense to have a cure period so that you don't have to go through judicial review? If he finds out that his voting status has been changed without his knowledge, his or her knowledge, give them a week or 2 weeks, a cure
5 days.
period to take care of it without having to go to anything else.
I'm okay with that too. I would,
Monday through Friday, 8 to 5.
Well, the point is though, that if it's found out that he's in default,
when does the 5 days
contract
start?
law, you're
When
in
he's
default.
notified?
If you don't have a cure period, then you're dead right then. And you've got to go to some extreme extent to get reinstated. Well, let's just give the person the reasonable benefit of the doubt to have some time. 8 to 5 doesn't cut it if you don't have a specified cure period.
So then 5 days from the time they're notified by the city council of the,
Or any-
Intent to remove.
sure.
About
Whatever,
5 business days,
Yeah, I was,
Yeah, you what?
5 business days. Business days is what we want to put.
It has complications,
whatever.
adding that caveat that they maintain the registered voter status. Because it could be done by mistake, it could be done nefariously.
But when notified,
So are you,
but if you want a cure period, when notified, that's when the clock starts running.
Then you've got
Yeah, I mean,
a certain number of days to get.
City council meetings, basically, now they're every week, I guess, but there's still 7 days in between them. So nothing happens within 7 days.
so 5 business days from the time they're
Appreciate it,
notified by the
really.
city clerk?
Can it be processed that quickly?
Can a change be processed that quickly?
They can go
What's
right
that?
down to Norwalk and get it done and
Seconds,
stamped
yeah.
and come back and provide it
What if they're overseas? What if they're on vacation?
together.
Saturday is a business day. What if it's an off Friday only for the city? Does that count?
I guess it depends on, well,
Those are business days. They're
Yeah,
not city business days. but
Correct.
They are business days. And there's-
Why not make it 10 days? And that would give you enough time to rearrange your travel plans and
come back from vacation.
get back and figure out how to get to Norwalk.
and
thing
if
I don't like
if they're overseas,
Well, how long are they going to be overseas if they have to be at a meeting once a month anyway? I mean,
well,
I mean-
no, so, but now, for example,
Of the year.
oh, I'm not,
They
because
are.
now you have the ability, unlike
Okay.
our 3 offices, they can leave the state for more than 30 days. It doesn't, clerk, city attorney loses their position if they're gone from Redondo 30 days. Council is not. And that was even when, before they could appear via Zoom.
You're kind of bitter about
Remotely.
that 30-day restriction. We got to get off of that.
You picked that up, huh?
Yeah, I did.
But city
It seems
council
like you
can
did too.
express permission
Right.
for that.
Yeah, but then again, you're always looking at the worst case scenario. What if you have a 3-2 split and it's an acrimonious 3-2 split? I only throwing this out because you do have to prepare for the worst cases because
So what are the other ways to change your voter registration back other than going down in person in Norwalk? I would imagine you could still do it online.
You can do it online.
How long does it take to do it online?
Yeah, but I don't know how, I'm not sure how you get a receipt back or how that works, that it's been taken care of.
I buy something online, they give me your receipt right over the, the
Screenshot.
next
that's what I'm
email I
saying.
get is a receipt. So,
Yeah,
yeah.
but then what we,
Mr. Logan's got to get his act together.
so in the city clerk's office, because we've had some of those situations happen in the sense of, they want to vote, they want to get it in. We have access, and so we can verify that they're in, and if not, we can call the county and ask them for.
Does a person that changes their registered voter locate, well, that's a residency issue, but if they don't register to vote, what do you have to do to maintain it? That's a kind of a key question.
and that's one of the questions because there's what the county calls the inactive file.
Yeah.
And that's because you just don't vote. Or we had someone who is very interested in the special election on a Wednesday in October and didn't get any of the ballot, didn't get any sample material. I'm assuming may not have showed up on the rolls for the proponents of measures or opponents to reach out to him. It was just because,
He didn't,
I don't,
never took his bail, so it went back.
right.
And
So,
the county assumed they were inactive.
But if you just
Too
don't
bad-
vote,
too bad
you
they
become
don't.
inactive, or you just stay a registered voter forever?
I think it's after
have to vote.
3 federal elections, they put you inactive.
you have to vote, and you have to have voted in 2 national elections.
Correct.
And after that, you're,
So within a
just-
4-year term, are you
no,
pretty
8
much?
years. Well, yeah.
You're
4 years.
inactive,
Yeah.
inactive. You're still in the system. You're just inactive, and you can still get a
You don't
ballot.
get the damn.
But you
And you're
can
still a
register.
registered voter,
Yeah.
but it's just inactive. It's not active. It doesn't have an A, it has an I.
Well, for purposes of our purposes here, we just need to decide whether or not we want a cure period or not a cure period.
Well, but-
And I think if you put a cure period in and just say, whatever, 10 days, I don't know, I mean, that works.
But I'm thinking, do we truly need this? Because within the period from which, they have to be a registered voter to file for nomination period, right? That's established. And if they do that, is there any way that they would be kicked out within 4.5 years?
If they hadn't voted in one previous federal or national election and another one occurred in the middle, yes.
Well, that really wasn't my concern. My concern would be more along the lines of changing residencies, to get back to that
That's a
issue.
separate deal, but
It is a separate deal, but
It's linked,
it's linked.
yeah.
But is there, as we talk about this, is there truly a benefit to adding verbiage that they must maintain their registered voter status?
I would be in favor of that, but I'm also
But if
not,
they're
I'm not
never gonna
opposed,
get-
I'm not opposed to the cure period to protect their, I'll just say position, from being hijacked politically. How's that?
But it sounds like if they are registered to vote at the time of nomination or appointment, or filing or appointment, they're not going to become not registered. Is there any?
Unless they move to a different area.
Unless they move, or like I said, they
But then
could be
we're covered with
inactive,
that.
but they're
They'll be
still
registered
considered a
at the other
registered voter in
address.
Redondo.
But that would then invoke the residency aspect. So maybe,
But what if they sit there and try to maintain that I'm still a resident of District 5 because I sleep on this bench in the park? But somehow I intentionally changed my voter registration to Palm Springs because for all practical purposes, I moved out there, but I want to maintain, I've got 3 months left on my council seat. And I mean, I have to admit, it is a kind of a stretch because now I'm sitting there trying to think of a scenario of why would anybody change their voter registration? Why would an elected official change their voter registration out of the city and then try to reverse it to say they didn't move? So maybe we are trying to swat flies that don't exist.
What about in the situation of a divorce? Or an eviction or something similar to that, something that happens common where you, in a divorce situation, the family house stays with one spouse and you have to find the location of another and somehow your mail gets inadvertently messed up in the process. I mean,
No, I understand. So that's how they get their voter registration changed kind of without them knowing it. And I get that. But are we trying to remove that person from office? I don't think we are.
I kind of look at this charter kind of like I do a bylaw. You're trying to anticipate the worst case scenario when everybody's got cooler heads. And that's kind of what our discussion is bringing out. Let's see what the edges are and see
So
if we
give
can
me
address it.
give me a scenario where somebody does not maintain their voter registration for, let's just talk about a council district. Give me your worst case scenario of why we would need to add the language.
Well, the one that I talked with Joe about was the 1988 fire and storm that came through over here. Or if we have a major earthquake that all of a sudden a large section of our population ends up getting relocated. You may temporarily, elections coming up, you may have to have that changed because you haven't been able to maintain that physical place that you had before.
Especially for a district,
Yeah.
but possibly for a city.
So
as
you're
well.
saying you would be in favor of having that person be removed from office because they no longer live in their district?
I'm looking at the intent.
We're back to residency now.
I know, but
And I
the
know
two are
there's-
linked and I'm not sure how I'm,
Eleanor, at the time of nomination papers, do you verify registered voter status?
Yes,
You do.
we do.
You do that one, and an appointment you do as well.
Appointments, yes, we do, for like commissions and stuff, yes. Or even,
So this isn't like other qualifications that are self-declared. This is something that is
we do.
really checked.
independently verified.
You have nominations, we check them for registered voters.
If a
too.
voter registration address is changed, does the person get a notification of it?
Yeah, we let the candidates know.
No, does the person? No.
We let the candidates know. so
That's
they
an
can-
interesting one. So if you're running for District District 1 seat, and someone doesn't want you to get it, they send in a voter registration card that says you moved. Eleanor goes in to check it.
You could sign up, though, for a voter notification online. And I don't know if that includes, like, for instance, the secretary is
Are you talking about the candidate or are you talking about the nomination? People that
well,
sign?
I
The
wouldn't.
candidate, they'll know whether they're a registered voter right when they come in.
What if someone changed it?
They'll know right there and then.
Yeah.
So then they can, they cannot turn their papers and to get that taken care
But
of.
if they turn them in on the last day of the period,
That's going to be a problem. I don't know.
or the second to
have
the
to talk
last
to
day,
them.
which is not uncommon,
We'd have to call the county and figure that out, and then I'd be talking to the city attorney. So,
but they would not be a registered voter at the time of,
Yeah, but once that's again where the cure comes in, or
There is
she
no-
does a verification.
there is no
She-
cure currently.
and that's why we
Well,
ask
I
the
don't-
candidates to come in early.
Let me ask you this question. Somebody gave you an application for office and it had false data on it, right? You pick any category you want. Would you call them up or would you just throw it in the trash bin?
No, we call them up.
That's my point. That's the cure right there.
We do that for commissions. and we
That's
do that for
that's the cure right there.
candidates. Yeah, we would call them up.
But that's policy, right? That's not written down anywhere.
Not written down. no.
Okay.
Well, there's no cure period right now.
I didn't say that, but she has a cure for the information that is received that is false. So if the person isn't a registered voter, the cure is when she calls them up and says, you're not a registered voter, you're not going to be able to run, the guy says, or the woman says, really? I didn't know that. And she says, well, maybe you ought to check with the county recorder. And
So
find
actually,
out what's going on."
we actually check when they pull papers,
Oh, good for you. That's my point. That's
because
the
then
cure.
they can cure it before they come in.
Well, it isn't really a cure, it's a check and balance.
Yeah. So, but that's not mandated, that's just a practice.
I'd have to look if it's mandated.
There's nothing that says you
I mean,
have
we
to.
do that because,
I agree, it's good practice, but there's nothing says you have to do that.
well, if you're in a district, we have to make sure that you're in that district.
But not
Or
when
in
they
the
pull
city of
papers.
Redondo, we need to make sure you're a registered voter because that's the requirement. So
The-
to pull papers, that's
Not when they pull papers, though.
when they pull papers.
But this just says at the time, is that the time of filing?
No, but we pull the papers to see if they're a registered voter. And if they're not, before they bring it in, they have to
Okay,
do.
but what I'm saying is nothing requires you to do that at the time they pull papers.
Her policy.
Yeah, it's,
But
I
there's
don't know,
not
I'd
even
have
a
to, I
policy,
have to
it's a
check if it's
practice.
mandated, but we just do it automatically.
It's a practice
Yeah, it's a practice we do.
that may or may not live
That's been-
beyond
So
you.
it sounds
been done before
like the
my
duties
time.
of the clerk to me.
Right.
It's been done before my time. We do it.
Okay, but I'd go back to, is there something that would actually trigger someone to not be registered as a voter
Fraud.
during their term?
Yeah, during their
And
term.
I'm not hearing that there would be. They may become inactive, but they're still a registered voter, right?
It's registered voter, yeah. They're in the system.
So as long as they have been verified as a registered voter at the time of nomination or appointment, that's it. They stay registered.
Okay,
So-
so what's your point?
My point is, now that we've talked it through, I don't think we need to add this.
What?
To this, add the caveat that they have to maintain their registered voter status throughout their term, because it sounds like it's going to happen no matter what. There's not a case where it wouldn't happen unless they triggered a residency.
Registered in Redondo throughout their
After
term.
talking around with it, I agree with you.
But that becomes a residency issue. and it's
Again,
covered.
I agree with that, but if you're registered in LA County and you're also attempting to register, let's just say in Riverside County, because you want to live in Palm Springs, that's a direct conflict and it's also illegal. But people, I can't say people wouldn't do that. And they could vote in two places until the Secretary of State catches up with them.
Okay.
And then the Secretary of State would say, oh, no.
We'll bring it back how we might add it in, and we can discuss it further then and see if it makes sense. But I'm seeing potential. that
I can
make it-
discuss things into the ground. I'm not gonna stop, you know.
It may be a
We
curing a
don't,
problem that doesn't really exist, is what I'm headed for. And I'm the one that brought it up, and I'm admitting that.
yeah, but I would say, again, you have to maintain your voter registration, or, something like that. I mean, now that you brought it up, and we're here to, I guess, put fixes in, I agree with that. They should maintain
Right.
their voter registration as it was when they were elected,
Okay.
as verified when they were elected.
Mr. Morocco, are you ready to move on?
Actually, you've talked about the city council people, the city attorney, clerk, treasurer, mayor, school board members fall into the same category, so you may need to expand on that, because it does say you're a resident for at least 30 days in the unified school district. So we need to be consistent if we're going to be consistent.
You struck a nerve there, Bob. He's speechless.
I am. I may not be a resident. Maybe
Well,
that's-
you don't have to be resident of Redondo, you just have to be resident of the school district. I don't know if
the same
they're
thing.
equal.
Well, in
is.
Redondo, that's the same thing.
It's the same thing, yes. It is equal.
Okay.
In this case, there
Yeah, right.
are situations where that's not
In
true.
LA, that's not true.
Okay. Anything else? Anyone else? Drug this horse through the sand quite enough here?
I think she's happy she's here tonight.
So thrilled. I get out of bedtime, I mean.
Oh, okay, tomorrow's a school day.
Okay, so I believe we still remain at just the one item for the city attorney, which was the 90 days and 1 year. Was there another?
I believe there was another one, but I'll look at the tape to verify.
You'll look at the minutes that are very detailed and we'll explain everything.
I'll look at the tape.
Registration.
Okay, is there a motion to continue this item to the
So for the
next
public?
meeting? I'm sorry, thank you. I'm missing that all the time now.
Okay.
Any comments from,
I have none for
Zoom or e-com?
comments, and I have none for a Zoom.
okay. Thank you, ma'am.
Kind of lonely tonight.
I'll move to continue it to next meeting.
Second.
Motion and a second to continue item I1 to the next meeting is all in favor?
Aye.
Aye. Any opposed?
Nope.
Item is continued.
And I also suggest whoever puts this together that we actually kind of rotate the order on some of this. If we're spending 2 hours on this one, this meeting, maybe we need to do it at the end of the next grouping so that we can stay fresh with our discussion?
Well, the order is based on, I guess, how the chair wants to
Right.
do it.
You
So
could
if
have
wanna
changed
change-
the order,
if
you know,
wanna
in the beginning
change
of the
it-
meeting.
I could have, and I intentionally
But you
left this one
didn't.
first,
Yeah,
knowing
you were
that we
given an
hadn't really
opportunity.
Okay, I'm
addressed
just,
I just want to point that out.
no, I agree with you on that.
And you can
And I
change
may
it.
do that next meeting.
All right, moving on to item I2, discussion of possible action regarding Article 11, Section 11.2 on the city attorney. Mr. Pinsler has his name on there in his absence.
Well, let's see what his surrogate has to say.
Mr. Conantuno.
He is
So
on.
two things. I would ask that if the council wished to discuss, and I'm not certain the committee is ready to discuss it, given pulling the blue folder item. Mr. Colantuno's been on since 7 to discuss any changes that the committee has or questions about the language for the charter, a possible charter review. And then I have some information about the Long Beach model that I wanted to present that the council had asked. And then I confirmed that Doug Halbert, the Long Beach City Prosecutor, will attend in person on your September 28th meeting to talk about their model.
We should continue with that.
And was that requested by the committee, or how was that established that?
It was requested.
You talked about it early on. We were going to reach out to city prosecutor and city attorney, but we wanted to talk to, you wanted to talk to Colantuno first about the language and if there are other sections of the charter that need to be changed. But since the item was changed, we may want to defer that to next month. My presentation can be given without Halbert as a precursor, if you wish to see it.
This item is not quite blue, but more heliotrope. Is that what you're talking about? The one?
Yes.
We got
Yeah,
tonight?
there was language
Who
that,
authored this? You,
no,
Mr. Pinsler?
the chair has it, and I don't know who he said.
Author this?
Mr. Colantuno.
This is from him.
Yes.
His name's on the back, says approved.
Yeah, this is the change that the commission's asked me to draft at
Okay,
your last
we
meeting.
did, we did. I didn't see your name.
It's for special counsel at the end.
But at this point, we don't have it.
Oh,
Yeah, 'cause
kidding,
it's-
I got it.
We haven't received
We
the
need
file. so
Camouflage.
We physically
Camouflage.
don't have it.
Yes.
Thank you.
Oh,
So I'm not sure exactly what we need to do. Do we need to return the hard copies to you, or
Sure, or you can receive and file.
we can't?
Of the
Let me
attorney,
sort of comment. I don't have any objection to that draft being made publicly available. I didn't put a confidential seal on it. It's simply an expression of my understanding of what you discussed at your last meeting. You may not be prepared to discuss it this evening. That's entirely up to you, but I don't think there's any need to treat it as something other than a public record.
yeah, so we may be confused about two things. He's prepared the draft language, and that can be received and filed, that's fine. He also was apparently, and I haven't reviewed the tape, requested to provide a legal opinion, which is not okay, is outside the scope of which he was hired. We had that discussion. You can't get a second opinion from an outside attorney, and that I would strongly, and that was emailed and was draft and confidential. And so I strongly suggest
Which we have not seen.
right, well, I believe the chair has seen. So I strongly suggest we table that to the future so we can talk about,
There's nothing to table. There is nothing to table.
right. I understand. So if you have any questions about, that's the purpose that Mr. Colantuno is here for, to talk through that. And I won't comment. What?
This paper. Okay. All right.
And I won't comment on that. I'll talk about the Long Beach model. I noticed that there was an item last time, and I don't know who prepared it, and there were comments in there about it's a much bigger city, there's no evidence that it would work in Redondo, it'd be cost prohibitive, and so I wanted to address that. And then we can have the Long Beach city prosecutor come talk, that since that was one of the models that the council specifically directed the committee to look at.
Well, I, for one, didn't get this until I got here.
You don't have it now.
What, this? Yeah, okay. But I also strenuously object to the chair getting information that I'm expected to discuss. Because you're dealing, it's kind of like the wizard, you know, you're pulling levers that with information that I'm not getting to see. So I object to that. That's for the record. So.
Okay, can we cut Mr. Colantuno loose for tonight? Have him come back when you
Yeah,
all
that's-
have
that's
this
it. That's
before
fine.
you. This will be on the agenda for next time.
I'm only one member here, so I'm just expressing my opinion about the decision-making process.
Why did we make him wait 2.5 hours before we
Yeah,
knew
well,
that
I
he was
didn't know he
online?
was on. I had
Well,
no,
and when he texted me, I didn't know he was going to be on, but apparently, as you know, I had a filing deadline on
Yes.
another case. I wasn't here, so
We can
that's
blame
when
the
I was
clerk.
texting, we were texting about the 30-day charter, residency requirement. And
Mr. Calentino.
yeah, and he
I
gave me
figured if you're
a,
paying for my time, you should get the benefit of it.
yes, and so he gave me a 65 case to look up. That 30 days is okay. Now, we don't know if 90 is, but that's when I first found out. So,
All the
Mr.
while I could be speaking to the ceiling.
Mr. Colantuno, first of all, I apologize for that. Who had coordinated the time for the recommendation or request that you be online tonight?
I thought that was my instructions from the commission at your last meeting. I reached out to staff at the beginning of the week to confirm, but I think this got complicated by Mr. Pinsler's vacation and a couple of staff vacations, and therefore this wasn't as smooth as it might have been.
and again, because of avoiding any appearance of conflict, I'm not coordinating.
So
You
who is
could've told
coordinating
us.
your attendance,
You were
Mr.
in the middle
Colantuno?
of talking about the other
My
item.
contacts have largely been with the city manager's office.
Okay.
Okay. He's not here for us to yell at. I got it. This is good.
Our apologies.
No worries. Are you in Dundee with me and done? Are you indeed done with me this evening?
I believe so.
Okay, I'll
Indeed.
see you in a month.
All right, good night, Michael.
Good night.
Thank you.
Bye-bye.
And we will coordinate a different time since we're going to have someone in person. And so we may do later in the evening. And I assume we may start with this item since we're going to have two guests.
I would make a motion that anybody attends the meeting on Zoom identifies it so we know who's listening and who's not.
Okay.
That's what I would say.
Was he showing that he was on?
Yes.
Yeah, all
Yeah.
night.
I think there was some confusion because I got your the memo, and then, he was asking if you had received it on Monday, and I didn't, then it came to me.
He's asking?
Well, regard.
Yeah, I reached out to the clerk and
Yeah,
manager
he-
personally today because I hadn't heard back from others.
And then you
I think this is just
provide the
vacation season.
reso, so there's just,
Okay, so Michael,
there's just
you
a lot
can-
of confusion.
Michael, feel free to reach out to me and I can at
Well,
least find out who in the city manager's office and get you an answer.
Well,
It's
Okay.
my answer, but it
I don't
would be
think
theirs.
we need to have an answer to that. I think we need to have, going forward, a policy if there's somebody on Zoom,
that.
especially someone who can give us legal advice and guidance available to us. In other words, we may have wanted to direct some questions to him that in previous discussions.
No, you
Whether or
can't.
not he's charged with answering them, he can tell us.
No, he can't. And so
So he
that's,
can't tell us?
no, he's for a set uh, um, purpose only. And that's with the language and the additional languages. And then should the item go on the ballot, and because I'll have a conflict and the clerk will have a conflict, that will go to the chief deputy clerk to advise her with the impartial analysis, since that is, and possibly defending an
chief
impartial analysis.
Our chief deputy.
How does this committee know that?
It's in the contract that he signed, and when we talked about this before. and
Does this committee have that contract?
We had a discussion specifically
Okay.
about that when you.
But we have the copy of the contract.
It's on the city website.
Okay.
But that still doesn't negate the fact that, our previous discussions about residency and things like that, how the language would go, because that's what we would be asking him.
But he's not retained
hired
for
for
that purpose.
He was
But you
hired for,
can't text him on
No,
that
he's
then.
hired for whether we get
He
a
was
city
texting
attorney
me, and I was thinking,
appointed or not.
oh, just that,
and he's
that
being
limited
billed
purpose?
for, he's being
That's a limited
billed.
purpose.
Okay,
That's a dual standard.
okay.
Okay, so why don't we
I thought
let
it was
Mr. Colantino go,
Yes.
and then we'll see him next month.
Okay, I will leave you then. Good night.
Good night, thank you.
Good night.
So I thought he was hired to smooth out all the language, but only for the city attorney.
Right, because
Okay.
and
My bust.
specifically, and we've talked about this, specifically, all the stuff that I did for you before on every other item, and how I suggested changes that may need to be made in other sections. All those, or practical considerations you may want to do. I can't do that.
I already took culpability for the mistake. You don't need to.
Okay, all right, sorry. Can you highlight my,
It would be nice to be notified if, since we're paying for him, that he's there so we can rearrange the agenda at the
Yeah, I
appropriate
had
time.
no idea he was online.
and literally, when he texted me, it's like, what, thanks, why are you online, was what I texted him. And he said, I was told by the committee, and since I wasn't here. So, this is, I'm going to give a presentation of my point of view. The thing that I think was Pinsler that wrote the attachment to last month's meeting. And so,
Are we talking legal issues here or policy issues?
well, this has to do with how we set up the legal office and how it will
But is that
impact,
a legal,
it's how it
question?
impacts the city. So
but that's not a legal question, that's a policy question.
ultimately, the decision is a policy question. But if you don't want information on how this will impact and change our city prosecutor and our city attorney's office, then I don't need to show you this.
Well, we just want to keep it to the
I
domain that
do.
you have, which is legal.
Right. and I'm-
Policy is not under the domain of the city attorney.
Right. You define that really broadly. I'm going to talk about how it impacts the operation of my office.
But that's not a legal question, whether or not it's,
What the effects of how you set up
no law pertaining to that.
if you don't want this,
It's
if you don't want,
what we want is matters of law.
the statement that was written by committee member Pinsler is, we have no evidence that the Long Beach model would be any better. Given that I'm a career prosecutor, given that I'm coming up on 30 years of working in Redondo Beach, I'm going to tell you,
But that's a matter of policy.
if you don't want to hear it from someone with 30 years of experience, if you want to make it a recommendation, because this is your job. Your job is not just to throw it to the council and say, yeah, have the voters vote on it. You're tasked with deciding it's no different than the conversations you've had with the clerk about how changes will impact her office. It's no different than the conversations you've had with the treasurer about how things will affect his. If this committee does not want to hear my view of how proposed changes and how this may or may not work, that's fine.
I want to hear
I
it.
want to hear it because we've been asking for the Long Beach model. So to the extent that we're going to decide the yes, we want to hear it or no, I'm voting in favor of hearing it.
Aye.
Aye.
And that's fine, but this is the clarification that this is the city attorney speaking on matters of policy, not matters of law.
Policy that affects the city attorney's office.
Right.
But it is.
And
correct.
therefore.
We've agreed.
Therefore
But it's
affects
not a matter
the
of
city
law.
at large.
It is
Well,
not.
I don't think he said that. I never heard him say that.
Correct.
But I want to hear his opinion.
I want to hear what the information about the
Yeah,
Long Beach model.
exactly, yeah.
Well, it's going to be how it,
We're going to hear that directly from the horse. Right?
you're going to hear that from them. So I didn't include, so they separate entirely the process. There are two divisions in our office. There's the prosecution division and the municipal law division. I'm going to give you, and because I'm responding to, there's no evidence that this would work in Redondo, and there's no evidence that, and I'm going to misquote, from the, I wanted to give factors for you to consider, and I'm not going to conclude that the Long Beach model is right or wrong, because I still don't know the costs. I'm going to tell you why the job has become so demanding on each different part. It may be worth exploring. So the biggest concern I have, and committee member Duiziak mentioned this, is a lot of committee member Pinsler has talked about he's wanted to change this for years, and a lot of it comes down to other cities don't have that. And so I talk about, well, what's the right number? 480 some cities in California do not have elected city attorneys. So if you want to be like them, don't have an elected city attorney. You have 125 charter cities. The vast majority of them do not have elected city attorneys. There are 12 or 13 city attorneys' office in the Long Beach model that prosecutes state matters. And that, unless you want to change the model, is, I think, where you need to look. This is a map.
I'm sorry, there are 12 or 13 what?
The city attorney's offices that prosecute state misdemeanors in addition to Long Beach. There are very few city attorney's offices that prosecute misdemeanors up and down the state. The vast majority have the DA handle everything. And so if it is, we want to be like most cities, which has been a constant refrain, then your choice is clear. We don't prosecute, we just have the DA do. But this is a map that you'll find it's really focused in LA, and for a variety of reasons. 10 of the 13, and it's 12 or 13 because Huntington Beach does that. We only kind of do quality of life crimes. They don't do all the state misdemeanors. So it's really 12 plus Long Beach, and 10 are in LA. And that has to do, and that's a long-seated, that's a long-standing proposition. And that's because I think voters want local control. LA County would be the 11th largest state in terms of population, and voters have traditionally wanted more local control over their cities. If you were just using population, because that's one of the things that stood out to me in that, and I didn't know if it was the synopsis, not having seen it, of what the committee had talked about, if it purported to be a synopsis. It was just one committee member's, because it said, well, Long Beach is far too large. There's no reason to think it would work here. We don't have the money. And I would say that's not true. Long Beach has many, many more attorneys, but they scale it up for the size of their population. So we did homeless court. They're adopting it, but they're scaling it up to fit the size. Pasadena is going to adopt it. They're scaling it up. What I want you to know is, I don't think, having run 5 times, I don't think our residents are looking for average. I think they're looking for better. And these numbers are all from the courthouse. And if you looked at population, we should be filing nowhere near that amount of criminal acts. And we're very aggressive because our residents demand, and if anything, they're demanding even more. So if you just went on population, we would be somewhere around 860, not nearly double the DA.
You're talking like we've discussed taking away the prosecutorial role, and we have not.
I'm not talking like that. There was specifically the Long Beach City Prosecutor model, and one of the bullet points was that, oh, they're too big a city. And what I'm telling you is.
Too big a city for what?
They're such a big city, that model wouldn't work here. And what I'm telling you is, it's not.
Nothing said that.
Can I finish my statement?
Well, not if you're going to make false statements. That was never said. Nothing about too big of a city.
Okay, so what I'm referring to is in.
It says it's a much larger city with a 3.2 billion budget fiscal year 2023 to be able to afford this.
Okay. And so what I'm saying is, that's not what controls the budget.
Nobody said it was what controlled the budget.
So then you can explain to me how they're a much bigger city, there's no way we can afford that budget. What is that based on, if not the size of the city?
Nothing says that. Nothing says we can't afford it.
What did you just read?
Long Beach is a much larger city with a 3.2 billion budget fiscal year 2023 to be able to afford this.
Okay, so that implies that we can't afford that, because we're in a list of reasons of why the Long Beach model wouldn't work. And I'm not arguing for the Long Beach model, but what I'm saying is, you really need to, and if you could let me finish my presentation, you really need to look at what level of service do our residents want? And what particularly do you want to recommend? So right now, we have far more aggressive prosecution based on the number of cases compared to the population than any other prosecuting agency in our Torrance courthouse. And so I think you want to look at, instead, if you're considering the Long Beach model, you're going to look at, well, do the challenges that we're facing, and this was one of the questions that Committee Member Pinsler had, how is this different from when I was city prosecutor? And I'm going to talk about that. And one of the things I'm going to talk about, I'll talk about challenges coming up, but we've had a long history of doing special projects, and they're addressing crime that just isn't solved with normal prosecution, the normal Hawthorne, Inglewood, Torrance prosecution. We do a lot of projects, and the problem is there are large gaps, and because those projects, when my time gets really focused on massive lawsuits or other stuff on the civil side, we can't do that. So I'm going to talk about briefly the history of projects we've done, talk about the ongoing challenges, and then things that you may want to ask Halbert when he comes here, in terms of, do you want, just don't reject it because of the size. There are reasons to reject it. There are reasons to adopt it.
Nothing's been rejected based on size. Don't make a statement like that.
Okay. I don't know what that letter was. If it's just one, and I'm not saying that you have rejected it, but that letter made it seem like there are no reasons to consider it. And what I'm saying is, there are reasons, if we want to continue the level of prosecution, public safety, and adapt to future challenges.
Not that had been presented at that time. They weren't.
Can I
Read things
just,
into things that aren't there.
I got a question about the previous slide. The numbers that were on the previous slide on the cases, is there a correlation of the numbers of cases that you prosecuted or were prosecuted to the number of reported crimes? In other words,
well, the crime level is much higher in
I
Hawthorne
understand that.
and in Inglewood, and it's a matter of
That's why-
our police department is more aggressive, and part of it is because they know the crimes are going to be prosecuted.
well, they don't decide what's going to be prosecuted.
Right, we do. And
Yes,
so-
you do. That's my
And
point.
so if we were rejecting it,
So using Redondo and Hermosa Beach as an example, because you should know that this number, what were the reported crimes? You prosecuted 2329. What would be a reasonable number of crimes reported in correlation to that number?
I think we had, I'd have to do some backwards math, but we had like a 95%.
So it wouldn't be that much more.
Correct, because
Okay.
anyways,
How many does Long Beach do? That number's not on here.
Well, the
No,
Long
it's
Beach is
not
not on there
because-
because.
the reason that's not on there, because they're not in our courthouse. And
I
I'm
got
using-
one more question.
Okay.
And that's a question for Doug. And it's many more because I think they have many more. It's the second largest city in LA County. And they have I looked at the Long Beach city attorney and they have like 26 attorneys. And it's not so much the method, but the size that will control the staffing and the budget. But the method is, the advantage of this, and we've talked a little bit about the disadvantages, and we will talk at the end about the disadvantages. The advantage is you can have someone whose only job is to focus on prosecution, which is getting more challenging, and I'll go through why, and
Yeah, so
has
the
been
Long Beach
challenging.
city attorney has 64 employees, 25 of those are lawyers, 2 are assistant city attorneys. Prosecutor's office has 38 employees and 17 of which are attorneys.
Right, and that has nothing to do with whether they have a dual function office or they are split in offices. That's the point I'm trying to make. When I saw that, it's like the second biggest, they have a huge budget. That's not as a result of having 2 offices. That's as a result of being the second largest city in LA County. Can I get through because this is like 3 of 30, and then I'll be happy to try and answer any questions.
3 of 30?
Yep.
30 slides.
Well, you're considering a fundamental, you just talked for 2 hours and 15 minutes on one item. If you don't want this, this is fine.
How about if we receive and file this?
No, I want to
That's
hear
totally
what he
fine.
has
I
to
think
say.
most of us asked for him to go ahead and do the presentation.
Yeah, I agree.
Okay.
Yeah, I don't know.
All right, so in LA County, there are always challenges, and one thing that we've historically done, having an elected city attorney with the city prosecutor dual function, is we've done community-based prosecution programs that are above and beyond. And we've gotten a reputation and deserve for coming up with creative ways to address them. So for example, we're one of 4 cities, and the other 3 cities are Long Beach, LA, and San Diego, which are all elected city attorneys that do prosecution, that have one of the first spousal abuser prosecution programs, and that led to directly the 24-hour-a-day, 7-day-a-week domestic violence advocates response team. Being elected, because my boss was elected, that became easier, because back in the day when we started this, domestic violence was viewed as a family matter. There were pre-printed forms for the victims to drop the charges, and it became easier. And even when we got the grant, the Mel Nichols, the chief, got drilled by 2 council members, one of whom was committee member Pinsler, over whether this was needed. Not having to have, well, anyways, I'll just say we're one of 4 cities that had that. I won't go through what went into it, but it made the prosecution of domestic violence a top priority. We had a problem with third generation street gang taking over a Perry Park. And I won't go through all that, but we had an 80% decrease. We had the first successful gang injunction with prevention component in a suburban area. We received a national award from the Police Executive Research Foundation, and Perry Park today looks nothing like it did back in the time. And we even had, national and state leaders come out here. Identity theft was a big program. That's hard to police departments weren't set up for it. We created a identity theft prosecution team. I'm trying to speed through. We had a 300% increase in identity theft arrests and prosecution. And again, we won award for that. We did enhanced monitoring and DNA collection, DNA samples from registered sex offenders. Homeland Security, when 9/11 happened, no one knew what it meant when we went on red or orange alert. The South Bay Chiefs of Police created a terrorism advisory group, and we created a program that was a model. And the state of California police officers standards and trainings had myself and two police command staff teach it throughout the sheriffs and police chief throughout the state. We had an increase like we're having now, but with auto thefts, and we did an undercover auto theft sting, and we won the Helen Putnam Award for excellence, and it was called the most successful sting in California history. And we have other community-based project, habitual offender. And now currently, and this takes up a tremendous amount of my time, a tremendous amount. And it has to do with the societal, perhaps the main societal issue of homelessness. And the city had a 5-year plan, I think, 10 years ago to end homelessness. And it was so out of control that my office was tasked with coming up with something in July 1st of 2019. And we wanted to focus on chronic mental illness, those with drug addiction disorders, and habitual criminals. We had a 44% decrease last year to a decade-long low, and it's 17.4% while it was increased countywide and around us. This year, there aren't
That's population.
What?
Population.
44% decrease. We went, and when they didn't have a point in time count model isn't very effective for Redondo. It works in big cities. They make a lot of extrapolation. They didn't release it this year. So we, ever since 2020, had CityNet, who does a point in time count in Orange County, do one, and it continues to go down. It was 16.5% lower this year. We've created the first outdoor homeless court, which is now a model. It's a Bill SB 67 that passed the Assembly to set up a pilot project throughout the state. And 57% of the participants have been either placed in temporary or permanent housing. And then we also have our interim housing, both the pallet shelter you referred to earlier that's filled with Redondo residents, Redondo voters, and we're getting people permanently housed. 57% get permanently housed, 52% from the bridge housing we rent in Wilmington, and the spa service provider Area 8 has a 17% increase. So I don't mention that just to say we're wonderful. What I mention that to say is that's where we are now. And having 30 years dedicated to that, that's a component, that's a feature of having a separately elected city attorney, because you can take risks, and the council, who may not understand them, is willing to let me go out on a limb because I'll propose that. But The Long Beach model may make more sense because the challenges I'm about to go through, and this is, I wish Committee Member Pinsler were here for that. Things that have changed since I was the prosecutor 16 years ago is Prop 47 and Prop 64. So the California voters, it's not just George Gascon, and I think his changes only impact us in that he'll file fewer wobblers, and those are crimes that can be either felonies or misdemeanors. He'll file fewer of those. But it's also, state law has reclassified a bunch of crimes that were felonies as misdemeanors. And a lot of them you're seeing in the news is theft of property less than $950. And so people are learning elsewhere there aren't consequences. You're having retail theft, and you're seeing all those examples. That kind of cries out for one of those special projects to make certain that people don't want to test our area, sort of like Operation Bull Market and the auto theft. Prop 64 also made a bunch of cultivation of marijuana, more than 6 plants, sales of marijuana. They were straight felonies, they're misdemeanors. So we're getting more and more of the criminal cases. So we file the vast majority of criminal arrests, or we get sent for filing, that the police department makes. I mentioned this to Committee Member Pinsler. It takes more time to do each case. When I was a prosecutor, you had the police file, you might have some evidence files, you may ask for additional investigation to do, to see what the parties said or additional. Now you have 3 to 4 officers who have body cams because our police department wisely mandates they turn that on. Well, that means, particularly in a DUI, like let's say there's a refusal of chemical tests, you may have to review those to see whether or not this is, we can prove it beyond a reasonable doubt. And then, it's a lot more discovery to turn over to the defense. Other challenges are there are a lot more diversions now, judicial diversion. A judge can dismiss any case, and we have to argue for a sentence or a resolution that truly is just. And we're doing a lot more. Judicial diversion didn't exist when I was a prosecutor. A judge could not just outright dismiss the case. There were minimum sentence. He could undercut you in sentencing, or she could undercut you in sentencing. Judicial diversion, mental health diversion, jail overcrowding. Typical sentence for misdemeanor is up maximum of a year, and people are being released far less. If they get sentenced to 270 days, they'll serve a tiny fraction of that, which again, if you're trying to deter a crime, means you're going to do more trials in order to get appropriate sentences. And then October 1st, no bail is coming to all of LA County. And that means that if the police catch someone in your stolen car, they can't arrest them and hold them in bail. They have to bring them, book them, and release them, where they don't have much incentive not to steal another car. The crimes that are on there are shocking. Possession of child pornography, distribution of child pornography are crimes that are book and release. So my point is, it is going to be in the future a very, very demanding job to get the same level of results, the same level of public safety that was done before with half of this position's efforts. On the civil side, the challenges are particularly the states. We're filing more and more cases, more often than at any other time in the 16 years I've been city attorney, challenging state laws. So we challenged SB 415. We won that because the state was trying to determine when we could have our elections and not let the voters handle it. We partnered with Orange County and a number of cities challenging the SCAG on our arena allocation that they didn't follow the rules. We have a challenge to SB 9, which will allow four townhomes to be built on a single family zone house. SB 10, which will allow a future council by a supermajority vote to get rid of our Article 27, which allows residential votes on all major changes in allowable land use. We're defending the city's recently passed or last year passed housing element against several builders' remedies challenges, and the council has already allocated money on to challenge SB 423, which will eliminate the protections of the Coastal Act against building affordable housing. So this is not to say you should do it, but saying that, and what I was trying to convey, Mr. Chairman, is that you should consider these factors, and the reasons that I saw on whoever authored that seemed superficial to me and said we don't have evidence. And I wanted you to know there is a compelling reason to split the roles so that they can focus full time. Now, what are downsides? Downsides, the cost of another elected position. You'd have two department heads. It's up to the council to determine what those positions would get paid. I'd argue that they should be paid equally, because that would, one of the things that was mentioned in there is there's a possibility of them fighting. Well, that's because the city attorney in Long Beach gets paid a lot more than the city prosecutor. And there was an incentive for the city prosecutor to challenge. I think the reason for that is if you're a city attorney, the most lucrative thing you can do is leave to go to a firm. And city prosecutor can't do that because they're going to want someone with municipal experience. But I think it would be wiser for the council to do that. Another problem, redundancy. You know, instead of the clerical handling both sides of the office, each different office would need clerical. It could be handled by eliminating the law office manager position and then having secretaries in each office, but there are many different ways to do that. But it certainly, and it may lead to an increased number of combined in-house positions. We talked about, you know, you could add an attorney, you could add a paralegal. For the prosecutor, Long Beach has an investigator, which is one thing we don't have, which has led to all sorts of problems with allegations of violation of the city campaign finance law, because there's nobody willing to investigate that. Reasons why it may not cost more, it comes down to the fully loaded costs of our in-house people are much less expensive than going outside. And I've referred to that, and I talked about unit of work. So a senior deputy city attorney is $107.70 fully loaded. Assistant city attorney, the second highest, is $146.05. And our outside counsel ranges from $250 to $990. Mr. Colantuno charges $395. I didn't put city attorney up there, and it's $207.10 an hour. And the reason I didn't put it up there is because, as I mentioned, I've worked here nearly 30 years, so I'm maxed out on the city's longevity pay. And so my successor, whoever he or she may be, may not be, but even at that higher level, it's far less expensive than our outside counsel. And so there's the potential to bring some of we get all the time, the lawsuits we get all the time, slip and fall on a crack, unsafe roadway. You could probably bring that inside if there were a paralegal and do that much more efficiently. But that's not to say I've run the numbers, I haven't. And that's not to say I'm in favor of it, I don't know. But I will say that the jobs in and of themselves, the two sides of the job, are getting to the point where if you want the same level of effectiveness, it may be wise to consider splitting the job. But that's up to you. That is a policy matter. But I just think you should dig into the details because our residents don't want average. And I go back to what's the right number to compare it to. So now I'm happy to try and answer questions.
So what's the difference from an impact point of view between having two senior deputy attorneys, whatever your title there was, under you, one having the responsibility of prosecution, one having the responsibility of civil cases, as opposed to two elected? I mean, I'm looking at my triangle, right, my pyramid and how it's split up, or however you want to call that chart, your tree. What's really the functional difference or practical difference of having, whether they're elected or whether you hire them? You have one city attorney, whether it's you or somebody else, you have one elected city attorney, and they then hire two attorneys who split the responsibility.
Well, you're going to have the more senior people. My time, and I answered this with committee member Pinsler, it's like I split, and I am splitting my job 50-50 between the two. And some days it's more we're doing homelessness and going through the other challenges of prosecution. And some days it's defending the city against a $500 million lawsuit with no insurance to pay for it. And it's hard to do that. And you'll have a more senior person who can set the policy for just focusing on whatever aspect of that job is. The other thing is you're going to get more people running for it. You know, one of the arguments in favor of going appointed, like the vast majority of cities do, not dual function, that's kind of split down the middle, is that you have the choice of attorneys everywhere. And you can use, you have a greater selection. The problem with that is there's no check and balance. And I didn't get into that because I thought the committee may be tired of me talking about that. But there are multiple Supreme Court justices who have talked about there are great constitutions everywhere. The Soviet Union had a brilliantly written constitution. The genius of ours is check and balance. And we have an unusual number of check and balance because that's what keeps one branch, one area of government. So the committee chair Stretzenberg is right. It's policy that the council decides. But the problem has not been me tailoring my legal opinion to any personal outcome I want to see.
I can personally attest to that.
There are things that I would like to see, but you can't you can't do. My job is to protect residents and taxpayers, and conversely, there has been plenty of pushback from council people towards infringing upon the duties of the city manager. We have a council manager form of government, and that means we wanted to take politics out of it. We didn't want to define policy as everything. We wanted to separate policy from the administration. Council members, in my experience, some councils more so than others, really push the limits of what that administration, and who else can push back on that? Not the city manager. If city manager wants to stay elected, it's the council person, it's the city attorney that can. And there have been examples, and I won't name names, but we had councils that fired an assistant city manager. And that's a blatant violation. In fact, it's a misdemeanor because they can't fire anyone other than the city manager. And to me, it's the overarching thing. It's all check and balance it. And you don't want a council deciding, okay, this is illegal. Oh, and you're the prosecutor, you work for us, and this is who we want you to we want you to prosecute. And that's a problem, not having that check and balance. It's a problem that council people, and they're elected to do the things that their residents want, but sometimes they don't want to hear what the law is. They just want any reason to, that will make it legal for them to do. And the voters have elected a city attorney so the city attorney can represent them and say, no, this is legal. It may not be what your policy preference is, may not be what my policy preference, but you're limited to that. Similar with the clerk, in terms of running elections,
Are we still on the Long Beach model?
Well, I was answering his question, so and that's why I didn't. So are you? Okay, never mind. So I was explaining to him, because he wasn't here when we talked about check and balance, why it's important to have a head of the office elected by the voters, focused on just one task. And that is the Long Beach model, 2 separately elected voters. And there are parts of the Long Beach charter that are stronger. In our model, the council could tell the city attorney at any point, we don't want you doing prosecution anymore. We want to go with George Gascon. So if we had 3 council people that want to do it under our present charter, they could prevent the city attorney from doing prosecution. Long Beach doesn't have that. And if we go to the Long Beach model, I would definitely recommend that that be put so that city council didn't. Now I was prosecuting someone who is a longtime tenant of Redondo Beach for child porn. And he had an attorney write in a letter to each of the council people that opined that, hey, you can tell him not to prosecute me. And it doesn't work that way. They can tell us not to prosecute all misdemeanors and turn them over to the DA. And I would think that part of the Long Beach model is better. But that is why that's an advantage. But the only reason you go to that model as opposed to leaving our model, and we've talked about the reasons to go to the draft language that you have, is that, okay, the jobs are becoming so demanding. We want one person to focus on one area, and we want to encourage, we want an expert in that. We want an expert in civil law, and we want an expert in prosecution. And right now, if you don't work in a dual function office, it's hard to have the requisite experience for both. But there are any number of civil litigators. We have 2 who are council people in the city of Redondo Beach, and there are any number of deputy DAs or prosecutors for other cities that could run solely for the prosecution model. So you get more challenges, more voter approval, but you wouldn't get, the council just gets to decide, because that may not be in the interest of the residents. And it's definitely not in the interest of check and balance, because nobody else is going to be able to push back on a council that says, we're going to do what we want to do, and we'll let people sue us. That answer your question?
Yep.
Okay, so there is no check and balance on the city attorney's office in only providing their position. That doesn't exist currently, other than a city council might make some statements, but the city attorney has complete control over.
Over the legal aspect, just like there are
I'm not talking about both legal aspects. I'm talking about the retention of outside counsel. Once it's in place, you have it. Budget control aside, the city council cannot, and we verified this, cannot retain anyone independent of the city attorney's recommendations. And Mr. Colantano advised us that we could just strike that within the charter as it is now.
So you could strike.
And that
it,
would
but
provide a check and balance on the city attorney's office, because there really isn't one now.
There is one, because that's what I was trying to say, as we've discussed before, it's the city council that retains the outside counsel. So it's a check and balance. I just can't hire whoever I want to hire.
But once they're hired,
Can I finish the sentence? I really don't interrupt you. So
yeah, you do.
Well, I apologize for when I do, but I would still owe you about a lot.
Don't take it personal, just
Yeah.
continue.
So right now, we have a check and balance, which is I can recommend and the city council can hire someone. And I've given the example. We have a lawsuit. I give them choices of whom they may want to assign a particular lawsuit. I've made changes in who we use based on preferences of the council. I used to use a firm a lot for land use. When the council majority switched, you may have noticed I don't use that firm. So it really is a check and balance. I can't hire anyone I want, but at the same time, the council can't just hire who they want because they don't like my opinion. Because you can find second opinions to say about anything. And there was a problem in LA where I think Mayor Villa
Mr. Woodham, do you have a question?
Some time ago, but you weren't paying attention. I had to speak up.
The question is this. I'm new to the committee, and I've sat through some of the meetings before I became a full-fledged member. But I'm still struggling with the issue of cost for the various models that we're looking at. The cost frankly, for the Long Beach model, if we had two people in your position instead of one. I don't understand what the cost ramifications are. I understand some of the argument for and against elected versus appointed, but I've not seen costs associated with those. And so I'm struggling to grasp those costs. If one assumes that there are benefits, if you take either side of the argument, appointed versus elected, in the final analysis, part of that decision, and maybe a big part of that decision, comes down to the cost. Because if there's a slight improvement in operation, but the cost increase is substantial, then that might not be a model that we want to adopt.
Okay, well, can you put my screen up? And I've talked about this a bit, I think, before you came on the council. When you look at that per hour rate, it's so much higher for the outside counsel that, and again, even another position like me, even if they worked 30 years and they had all the longevity, only cost $201.70. And so any unit of work you get from that person. So if the council wants, I can give a model, like if I were doing it, how I would propose to the council. And then you can compare that. I would mostly save money on money that comes from litigation matters right now. So instead of using an outside firm because somebody slipped and fell on a sidewalk crack of more than an inch, I believe that with the number of cases that we have and the much lower rate, if you're billing 107 an hour versus 250 an hour, so taking the lows, I find it hard to believe that would it wouldn't cost less. So even again, my position, 207 and 10 cents an hour is less than our cheapest outside counsel. So you can get, and and we don't bill overtime, and that's fully loaded with PERS and everything else. I got the numbers from financial services. So if you want, I can show a model. Yeah, I won't guarantee that that's the model. But that is, that is a concern. You don't want to do it where it's going to spend cost a lot of money. But the more work we can do inside where it costs so much less, I think there are savings. And if it were neutral, then I think it would be a much better model. But I don't know if it's neutral. So that's why, I'm not opposed to it because it retains the elected. But I'm not saying, yeah, this is the best thing since sliced bread. So if you want me to, hey, here's a model with numbers next month or for what I would propose and how it compares to what we currently pay,
Mr. Morocco's next.
I can do that.
I would personally like to see some analysis along those lines.
Okay, just know it's a possible one because I won't be here whenever this went into effect. So each prosecutor, each city attorney, each council may give them different things. I probably will, for example, include a city prosecutor investigator, and then I'll compare it to what the potential budget would be for, maybe I won't, that's too ethereal. I'll just go through, I'll compare it to what we spend if we did 5 cases or 10 cases in-house instead of using a firm, and I'll take the actual billing amounts for those firms and compare it to what the in-house costs for the additional people.
Mr. Morocco.
I would like to get a copy of these slides if possible, so we can analyze it. I'm looking at it's 10:30 now. We're going to be taking up this topic next month, and I appreciate you putting together the information that we have, and it's I think going to be helpful when we do the Long Beach model, but I do think at some point very soon we need to move on to the next topic because we're going to be coming back again next month on it.
Just because you have a job, don't take it out on a resident.
And again, I wasn't here last month, and so I saw the reso and I saw the minutes or what, the statement from Pinsler, and I just didn't want you to make your decision in the absence of knowing how the Long Beach model
Mr. DeWitzik.
could affect our office.
These numbers on costs, are these derived because you guys are classified, not hourly employees?
Right.
Did you just take, a 40-hour work week and
Yep.
divide it? That's how you
Yep.
came to, okay.
Yep, and so if we work more.
Okay, because you don't get paid overtime. I mean,
Exactly. So Mr. Colantuno made, what was it, 2 hours? and
Whatever he
15
made.
like $900, $1,000.
and you're showing a whole lot of envy tonight, so
So,
let's not get too carried away.
yeah, so what I did is I asked for
I
the
just wonder how you
fully
do-
loaded cost and then divided by
Just wanted to know how you
2,080.
derive the numbers. All right, that's it. I think Emily,
I have a question. So when you're talking about your hourly salary, are you talking about your take-home salary, and are you also including your benefits package in that?
Yes, I got it fully, I got the fully loaded amount from financial services. So they do everything, including PERS, including longevity. That's why I was saying,
Okay.
like, the 20710, I'll letting you know because I don't have a problem, but I don't want you to focus on that because you've got a 30-year employee and that's maxing out the longevity pay. But
Yeah.
that's worst case scenario.
can't focus on something you didn't put in the slide.
Which is why I didn't put it in the slide, but I wanted to let you know. But yeah, I didn't want us doing it. I wanted to get it. So like, for example, when we initially applied for the Hermosa Beach City Prosecutor job, I asked financial services for their recommendations for the amount, run fully loaded, and then, give us a hefty cost, a profit to be able to help them by sharing our excess capacity. I did something similar, and that was the total amount of it, and then divide by 2,080, 40-hour work week.
And you did the
52
same
weeks.
for Manhattan Beach?
What?
You did the same for Manhattan Beach when that was proposed?
No, because, well, I did something similar. With Manhattan Beach, we'd have to hire somebody else. So with Hermosa Beach, it was, we shared a courtroom with the DA, they shared a courtroom with the DA. I approached the presiding judge and said, will you put all the DA cases in one courtroom? And because half the time Hermosa was waiting around for the DA cases to be finished, we were waiting around. And so I only applied when they said, okay, we'll move everybody into the, Hermosa Redondo courtroom. So it made sense because we could share excess capacity. With Manhattan Beach, we still asked to move the Manhattan Beach to ours, and they said yes, but we needed another attorney for trials because, there was a risk we'd do more trials. And so we did it slightly different, but
In the numbers to Manhattan Beach, the hourly rates are like $20 an hour or less.
$20 an hour.
I took my question right away. I want to know if it's true.
I'll add it to the next meeting so you can see what that documentation shows.
Okay.
You charge them by the hour, Hermosa Beach.
No,
Manhattan
it's
Beach,
a
Hermosa Beach gets charged by the
proposal-
hour.
They
Manhattan.
get charged for 200,000 for the year.
Okay, so it's a blanket fee?
Yeah, it's a blanket fee because you can't do hourly things, and that's why I'm curious what's in there. Well, because it disincentivizes going to trial. And so you don't want to pay a firm to do prosecution because, then your budget's going to be hurt the more aggressive you are on crime.
With Hermosa Beach, that's a firm that does that?
No, we do it.
Yeah, that's what I thought, so.
Yeah, and so we just charged them. We didn't do a firm. We said 200,000. And because we're combining them and,
Right, okay. And again, I'll go back to the previous slide of cases that were filed versus the crimes that were reported. That would be your office that decides what's to file,
yes,
and that fits in the 200,000.
yes. Now, it's changed and it.
Okay, all right.
That's the
That's the model. That's
City
the model.
council,
That's the model.
it's been for a while and the city council has given direction to the city manager to approach Hermosa Beach about increasing the amount. I had recommended it to the previous city manager and then COVID hit and they decided, okay, now might not be the best time. But yeah, we always decide that and we don't factor in.
It's a learning experience for me. I'm with Mr. Morocco, by the way. We need to,
Yeah, there was a
Table
comment
this or
made at
push it
some
off
point that the Long Beach model could open up the pool of candidates and have more people running. The Long Beach data doesn't really support that. They're a city that's 6.5 times our total population. Last time in 2022, they had 2 people run for city attorney, 3 people for city prosecutor. Time before that, in 2018, nobody challenged. The incumbents just got it. Nobody wanted to run for it.
I would argue that the population has a whole different demographic in Long Beach than it is in Redondo Beach.
You could argue that.
I could, and anybody wants to challenge me, I'm ready.
LA's
challenge
got an
you.
even bigger population. They didn't get that.
I didn't say bigger, I said different demographic,
It's completely different. but they
completely
still
different.
didn't
And
get that many.
you're not gonna get as many qualified candidates running in Long Beach as you're gonna get in Redondo. No matter, we just have more lawyers and per capita. I mean, just that
I'm
simple.
happy to look at your data.
Huh? So, it's online, I'll get it for you. Okay.
So, yeah, it just, and the difficulty becomes that there's only that one model to compare to. There's not anything to be really gained from a one-off comparison.
So I move we
I agree-
table
I agree with the
discussion
judgment call.
to next month.
Second.
I want to make one more topic first. The timing of when this should go to ballot. You've challenged that, to said that's not under the purview of this committee.
Not asking for a legal opinion about that. The council certainly can change it. You can recommend whatever you want.
But it's not, we're not precluded from doing that.
No. You're not from doing what? If you could.
From talking about elections, that different items would best go on.
It depends. So the clerk and treasurer was clear, you were told November of 2024. I think you were told I forget the language and I don't want to quote it. It's let them know it's very likely, or it's likely that we're going to put it on November 2026. And actually the person that voted against it because of the restraints. But you can, if you want to put it on March, that's fine. If you want to have a discussion on, and we're going to have discussion on the school board, because I don't know when you can put that on yet, because I need to meet with the school board's attorney. Those same issues may come up with a couple of exceptions.
Point of clarification, I thought the school board had to be on a statewide ballot. No? Can be on a municipal ballot?
They are on a municipal.
I know they are
No,
on, but to take them out of the charter.
Well, that's.
We had that discussion.
Yeah, but I said, I don't know, because we
Okay.
need to research it, because,
So we don't have that answer.
well, so is that on this? Because if we skip to it, I can
Yeah,
talk
let's
about
not go
that.
down that direction right now.
Okay.
Well, because a lot of those issues will come up, and that is before you.
So I thought maybe that was in one of those private emails you guys throw around that I don't get.
That I can't pass on to you.
Okay, well,
So-
that's not gonna stop me from
And I had
bringing it
asked you to
up.
provide the election code information.
And I did to you verbally. I said, it's not part of your discussion because the council took that away. And so at the.
The current resolution that's passed has no language.
At the June meeting,
Yeah.
at the June meeting, well, actually, it does, but at the June meeting, I cited you to the report before the council where, at a meeting you were at,
Yes.
where the clerks,
The November 1, 2022.
right, that had all that information.
And it does not have all the information. I have a copy in front of me. And nowhere of this report that you alluded to that had all the information you said we need.
Right.
Nowhere does it mention the primary elections.
It mentions 1415, which is the
It
code
does not-
section that you asked.
But and then it specifically eludes that topic. So I would say that information was incomplete.
Well, I'll be happy to talk to you during the school board election about that.
Okay. I did talk to, at the request of committee, I did talk to Councilmember Barrett. We don't have to go into that tonight if we want to move on. Any Zoom or e-comments?
So I have none for the Zoom or e-comments.
Okay.
Not for this one.
Right. Motion and second to table to to continue to the next regular meeting is on the floor. It's on the floor already.
Second.
We have it, correct?
Yes.
Okay. We have a motion and second already. All in favor?
Aye.
Aye. Any opposed? None. Continues to next meeting. Get back to the agenda here. Okay, I3, discussion of possible action regarding Article 11, Section 11, City Clerk, and Article 10, Section, or excuse me, Article 20, Section 20.1, approval of demands. This has Mr. Penzler noted here. Does anyone have any information or commentary on this item?
Yeah.
Mr. Morocco.
So thanks to the city clerk finding the 1965 ballot proposals, you have your blue folder item. It is not an instance of, has been presented at this meeting, of somebody feathering their nest. It looks like there was a robust discussion at the council as to why they needed to add the accounting requirements. And in fact, there was almost unanimous with the exception of one, I believe one council person who said that they thought that it was an important reason. So I'm still in favor of keeping in the accounting things, as our Mr. Duiziak points out. It's always good to have good qualifications. The financial requirement is still there, and it isn't something that was nefariously put into the charter by somebody who was overly ambitious on it. So that's my 2 cents on that.
Still my position. It's still my position. Just the way I am. Hard to get me off the dime.
Anyone else?
What are we opining on?
Oh,
I mean, I know what the topic is, but
We're not so much opining. Mr. Penzler once had suggested that we pull out the accounting requirements, and we've been going back and forth over the last several months about should it or shouldn't it be, and
why it was put in the first place.
right.
so,
That's what we're about.
okay. Well, I guess my position is if it ain't broke, don't fix it. And there's nothing about the city clerk. There was some language, I think, that was proposed to clean up, which I'm all for. But other than that, I just don't see making any changes. I'm not really in support of making any other changes to the language of the city clerk with regards to the charter.
Well, I think Mr. Morocco's point is that rumor control has been put to rest by Eleanor's ability to dig up the minutes. Of course, she couldn't give us the videotape because after 20 years. I appreciate that story.
It'd be grainy at this point.
Well, it would have been 8mm tape or film.
What do you want to do with this?
Well, it's, what remains is, are there recommendations of change to the charter?
I thought he had some revisions.
The only change I would make would be to make the requirements a little more stringent. Education is not a bad thing when you have people, I'll just say, acting as a fiduciary.
If I can get some clarification from our city clerk, 62223.
You might want to look at the 72723, because that was the last version of proposed language. Page 3 of 3 talks about the city clerk.
Which number is that? God, they all start to look alike. The agenda packet has them numbered.
Right, so it's the one I recommended.
It's number 3, I believe.
It's
Number 3 of
622, I
the,
think. Let me look.
is a red line version.
Yeah, the 622, the blue folder,
Yeah, 'cause that one's not a,
which is
Red line
number
622?
The 6/22/23 blue folder.
Okay.
But I know that per the last couple of meetings, there were some changes.
Yeah, that's what the third point on the, was the latest that Mr. Pinsler presented at our last meeting. But
That was voted down, the last one.
Oh, that one.
that's 622?
Yes.
Right, that's the one I was looking at.
Same thing, I guess.
It's got the blue.
One,
Right.
one's red.
Correct,
Those are your changes. Correct?
correct,
That you support.
correct.
Yeah, it's the same thing, it looks like.
Okay. I'm all for amending the language to reflect that.
Same.
It's not, well, this is the
You
more
want six-
recent one that you did.
You're on 6/22/23?
That's 727.
I want blue folder?
Yep, I'm looking at 727, which was what we
Which
did
one?
last month.
Okay.
Oh, 622.
And Eleanor, remind me again, which one was your,
Mine was the 6/22/23
the blue folder item?
blue folder item. That was my recommendation. But I know you guys had some issues with some, like I had 10-year, you guys were looking at maybe not, and then I was taking off the courses, but you felt it should go back in. So there was discussions last time.
Yeah. I think the main difference was on E to start with, that the oversees the city elections. And then I thought the other thing was the coordination between the city manager, the finance department, and the clerk. And so if you look at, I think it's F6, where it says,
To
looking
approve,
at
accept as-
622. Yeah, I think the one from 727 is actually better worded to, within 30 to calendar days in conjunction with the city manager, approve and accept its correctness. All bills, invoices, payrolls, demands, charges against the city governor. Any items rejected by the city clerk shall be immediately put forth to the city council. I think that was the gist of what happened in our discussion on June 22nd. Which unfortunately, the minutes were rejected.
Okay, anything further? Or does everybody want a little more time?
Okay.
What are you proposing we do then?
I am not proposing anything at this point.
Do we want to revisit this at the next meeting, or do we want to take an action tonight? That's, I guess, the first question.
Well, I guess the first question is, are there any other revisions to this that anybody is suggesting?
I think they were still suggesting on the E section about overseeing all city elections, and that's, I don't think that we've had any controversy over that. And then, other than the accounting units, which I think we should keep in there, and I think really all we're doing is changing E, and probably the part about the coordination with the city manager about, because there was some discussion about what if they don't get along, the manager and the city clerk, and what would happen. So I think the July 22nd part about the coordination makes some sense.
I don't have any problem with the education part. Did you, Eleanor? Why did all that get struck out? With the passing grade of at least 15 units consisting of, was that on our recommendation that got struck
That
out?
was
Bob's?
Bob's.
Yeah, and his findings were that that language does not exist in any other city charter.
And if you look at what happened from June, it all of a sudden went from these specific accounting units, which are verifiable, to 10 years of experience or 5 years of experience, which didn't translate very well. And I guess we left it with an open question about whether the city clerk verifies that the candidates actually have this experience.
I do remember that discussion.
That discussion was last time. Right. And so I don't verify. I said, I don't verify. And I think the other issue is that it was easier to verify if they have units.
But you don't
versus-
do that.
No, we
Yeah,
don't do
and
that.
we've discussed that that's simply a self-proclamation.
Correct.
Yeah, and then we talked about too, that just even the wording 15 units doesn't always have meaning. It may in some cases.
So then I can make a motion, if this helps out, that we leave in the section with regards to the accounting units as the first point, and the second point is that the language related into the coordination with the city manager and the fact that it goes to the city clerk. If there's a dispute, it goes to the city council immediately, be added as a change on that.
Is that for 3 or F?
What?
Are we talking about F or 3?
We're talking F6, the one
F6.
where they added the words within 30 calendar days in conjunction with the city manager. We had a robust discussion last month on it. You wanted to keep the checks and balances, and I think I may have been Bob that brought it up, that what happens if the city clerk wants to hold the whole thing hostage, what can be done? And that's the language, I think, that was worked out from the June meeting.
So if this were the case currently, if it was a 30 calendar day limit, would you be completely caught up? You have nothing that's older than 30 days at this point?
No, we don't. Yeah, we don't keep stuff no. I mean, when I find something, I try to get it done within 24 hours.
Yeah,
Because-
you don't have a backlog
No,
of
no,
anything?
You have any grudges?
no. I mean, I want to get the vendor paid too, but it's usually errors that, we might have already paid them, or, something's missing, that kind of thing. So usually majority of the time, it's always been resolved.
There's a bogus credit card bill. That actually happened to me when I was on council. There was a charge that appeared. We were all issued credit cards that we never used, at least I never used mine. And some charge appeared from Australia on the credit card. And I'm like, what the heck is this? You want a real good laugh? You know what it was for? It was ostensibly for bald treatment, hair treatment or something. So obviously, whatever it was being charged on that credit card. I was not the beneficiary of it. That's all I can say. But- So are we at a point when we can all bless this and as to the final form for a recommendation to the city council for changes?
We would have to have that final form. We would have to have that final form.
You don't like it with just the
No, we don't,
strikeouts?
we don't have it. We have,
Strikeouts.
yeah. Well, no. I don't think either version is, Mr. Pinsler's version is the 727, and that has the experience and eligibility requirements struck out.
So who typed this up in the first place? Is that coming from?
This one I did, the one for 6.
June?
Yes, June.
The 622.
Yes, I did that one.
Part of the problem is we don't have headers on these to know.
Can we get a clean copy of the 727 one with the, keeping in the accounting units, but also getting a red line version of what's, so we get a clean version of what we think it should look like, and then we get a red line showing what we struck out? Because I think that's what you just asked for.
Yeah, because to be at that point where we're ready to recommend language, we have to have that language. And what I'm saying is,
Fair enough.
we sort of have it, we have it conceptually, but we need to,
See it on paper.
right, and really finalize that.
I'm for that.
Okay, so the 722, I don't know if
727,
727 was provided by,
Pinsler. And his name is at the top of that document.
because it's,
So it's the one
But
right.
he's
right
striking
before.
out stuff anyway, so it really doesn't add too much. So it's something that
Right.
probably you can do from what the existing Word template you have.
from the one I created.
Well, from the actual charter.
Right, well, the one I have is just strike-throughs of what I think.
Yeah, so
That's
if
what I'm
you
saying.
take the positive, this only looks like there's maybe 15 words that are actually changed in it, other than the strikeouts.
So you're asking me to bring the 622 one?
No, I'm asking you to bring the 727 one, keeping the accounting units and giving us a clean version of what it looked like without all the strikeout terms.
Okay, so the one I'm looking at, 722, there's two of them, and one has red.
727.
727. There's two of them, and one's in red.
Yes.
Okay, so pretty much that's taking out all the accounting tasks.
Right, but we're going to leave that in.
Oh, I see, okay, that's what I was,
So the only real change is going to be in paragraph E, and that's starting in, I guess, paragraph 6, where it talks about how to resolve it. So again, I don't think it's more than 15 words.
okay, and then leave everything else in.
Yeah, unless you were the one who was doing all the strikeouts and the language changes. I'm just trying to figure out who should be doing that, so.
Well,
I'm still not sure which version that we're working from. What I did, you told the clerk and I to work together after committee member Pinsler had did his original to come back with a markup. And I think, if I recall correct, I was in purple.
It's the 622.
Yeah, the
which is
620.
blue, has a blue
Right.
tint to
So
it.
which one do you want? And I just am having trouble finding on 727, which item do you want?
Which is marked in red, is what I'm hearing.
So again, I'm looking at page 3 of 3, and
on 727.
on 727, I'm assuming, and maybe I shouldn't assume, that the reason it made it to 727 is because we had a very extensive discussion on June 22nd, and this is the latest version, if I'm
Oh,
wrong.
I don't think so. I think this is, you may want to, I think this was a committee member's view. So I think you still have two different visions. The clerk's vision, which was 622, and then committee member Pinsler, which was 727. And you just have to say which one you like or which combination of the two.
622 is in blue, right?
Yes.
Okay.
And I can't find the one in red.
Neither can, well,
The
the one in
second
red.
one for
is-
727.
Yeah. That's the,
It's the second,
Bob's
It's
version
Oh, I
is
see.
the
So it's-
section 11.
It's titled
He's got a copy of the charter.
727 Redondo Beach City Clerk Revisions.
Oh, I
Dash
see. what you-
CRC
Yes.
PDF.
the last page.
Okay, I see where you're saying there's differences, and we did discuss that you would be reviewing journal entries from 622, and that's if I recall, stayed there. I guess the only thing I would say that we may want to vote on is that we keep the accounting units and that section talking about no person shall be eligible, that whole paragraph, just leave it alone and just then reconcile the other two.
I mean, I'm fine with keeping the educational requirement in. I don't have a problem with that.
The 622 version?
Well, there's I guess I'm happy to go fix this whole thing up and reconcile the two. And I'm sure Bob will be back next month, so we could have a more full discussion on it anyway.
I would agree with that. I'd hate to, at this point, kind of close him out of it with him
No,
not here.
I wouldn't want to. 'Cause this is
And
part
even
of
the
his
last,
dream, yeah.
the last paragraph, the city clerk had even proposed to remove
Right.
some of the educational language. And that was in
No,
agreement.
she was, if I remember the conversation right, she was accommodating us
Correct.
because she's trying to
And
be
then you
nice.
guys decided to put it back in.
Yeah, yeah,
That's what I'm
And
just,
we found the 1965 stuff, so.
right.
I'm curious if anyone would be open to changing the language to require more experience as opposed to
Oh, I like
education.
you. I like you. Yeah, I'm
I
all
think-
for that.
We were looking for the verifiable stuff.
Mr. Pinsler may plant a small explosive device
Well,
at your house.
apparently nothing is verifiable, the work or the work
It's not that
experience.
it's not verifiable, it's just the fact that it is
Not
not
Nobody does
verified.
it, yeah.
Not verified.
So it is
You're
up to
making
the
a
voters.
representation that can be at some point challenged, and then at some point, people would go look at the record. So if I said, hey, I have the experience, and you say, no, I don't, it would be incumbent on me to produce transcripts that show, hey, I've actually done this kind of requirement.
That would show 15 units, because otherwise it doesn't meet the city charter.
Or the equivalent.
There is no equivalent.
Well, that was the managerial or the
Right.
government accounting of 5 years.
But there's no equivalent to 15 units, being units.
Yeah, well, yeah, you've made that
That
point.
specific language is,
Semester
could be
units,
challenged.
quarter units. And it does tell you what kind of accounting classes you're supposed to take.
yeah, which though even those definitions may be
No, this is,
subjective.
no, actually it's not, because when I applied for the CPA exam, they went through and said you needed certain classes and they described them. And that's similar to what that says there.
Want to go back to the
To your point,
discussion?
though, there's been some discussion about would we change it to have a city clerk's, what's the official
Certificate?
recognition that you're a city clerk and you've passed training or something? There was,
oh, city municipal clerk, something like that. Is that what you're
yeah,
alluding to?
we had talked about potentially putting that in there.
No, but
A
you can't-
professional organization?
Yeah, but that, you have to do it once you're city clerk. That was the problem with that.
Okay.
You have to be a city clerk.
Kind of favors the incumbent, huh?
Well, you have to be, yeah, you can only, well, it's related to if you're in the city clerk's department, you have access to association, and then you have to do 2 years worth.
Okay, so you have to be a city clerk in order to attain that.
You don't have to be a city clerk, you can be, but in the city clerk department. So you
Okay.
could be a,
So it could
someone
be
in my
doable.
If
department.
somebody was working in the office for 10 years as opposed to 5
Correct.
years and all the education, then they could.
Well, for this, they would have to have the accounting. So, but if you wanted to put something in there, I mean, it would be people that would be in the city clerks as a city municipal clerk. That would be the only way, if you put that in there, it'd be people that would be in the city clerk's departments that technically join that association. And it takes about 2 years.
I'll volunteer to work up some sort of reconciliation and run it by Bob and maybe come have at least 1 or 2 proposals. I think we're all losing effectiveness at this point. And we're slowing down a little bit, so. Okay. You don't get up at 5 to go to work.
Okay, so is there any kind of motion?
I'll make a motion then that we keep in the education requirements in this, and then I will come back to propose to Bob the reconciliation between 622 and 727 and give a clean version and a red line version to the city clerk once I talk to Bob. Assuming he's coming back. in
I'll
time.
second that, but
I think he's in Africa, isn't he, or something like that? Do you know when he's coming back?
He'll be back for September.
Enough time for us to.
Oh, as far as, I would think so. I know we had talked about that. It was more predicated around Mr. Solomon, that we had a meeting with the city manager. We've done that already, so I don't remember the exact dates.
I'll coordinate with Eleanor and at least get Bob something.
Okay.
And then if he wants to propose something, you'll have 2 things in front of you.
3.
3.
Okay, that's your motion?
well,
Yeah, I
Well,
don't remember it, but yes, it
I'll
is.
second that, but I want to either see that in the agenda when it's published on Monday, or I don't want to get it in the red folder or the blue folders either, because I just don't like to hide the ball on the information game. That's just the way I am.
Gives me something to do over Labor Day.
Well, I don't care when it's done. I just want it more than the day, in advance of the day that we're gonna discuss it. That's all. It's gotta be on the published agenda. As a part of my seconding your motion.
I'll adopt that as part of the motion.
Okay, there's a motion and second. All in favor?
Aye.
Aye.
Public comment?
Oh.
Public comment. Is there a public?
None.
I don't think we had public comment on the last one either.
None. Thank you.
Are they awake?
Any opposed? Passes. So it's continued to the next meeting, next regular meeting. And you will work with Mr. Penzler to come up with a compromise language. Okay. Back to agenda. Next item, I4, discussion of possible action regarding the possibility of removing RBOSD school board from the city charter as directed by city council. I will kick that off, that there has been no further action by the school board.
But you guys are having some meeting or other with regards to that issue coming up. I talked to somebody today. Correct? Yes, no?
It's been proposed. We don't have a date of anything yet.
Wasn't there supposed to be a meeting between the school board's attorneys and our city attorney that was supposed to happen?
Yeah, they scheduled it for August 14th, and then they said they couldn't make that. They gave dates next week and the 21st, which was Monday. But then they said that they had to change that, and so they've now given me dates in September. And so I have to look at my schedule and see. And I think it was, before it was Enos with the school board who was contacting me, and I kept repeating that it'd be good to meet with their attorney. And it's Joseph Larson, is that one of the attorneys?
I'm not sure.
Well, I got contacted by Joseph Larson today that proposed dates. And we have a number of court hearings coming up in September, so I got to find a mutually convenient one for us to meet.
So the thing I'm seeing with this, it doesn't seem like the school board's really interested in removing itself from the charter. And at least that's the impression I'm getting. So maybe we just need to say, okay, if you guys don't come back to us saying that you really want to be leaving the charter, that we both vote down sending this on to the council for inclusion in the election.
I agree with that, but maybe we should just give them a chance. What'd you say, next week,
September.
September?
Yeah.
Well,
We had 2
our next
days.
meeting is in September. If they don't respond, we vote them out. How's that?
Fine with that.
I'll make a motion to continue this item till September.
Okay, before we do that, is there any public comment?
Yes, we do. We have public comment. So Steve Chesson.
Thank you. My name is Steve Chesson. I'm president of Californians for Electoral Reform. I did submit any comment, but in case not all of you have read it, I'll read it into the record here. It really does puzzle me that you continue to discuss removing the school board from the city charter without a formal request to the school board for their opinion. Well, I do know that committee chairperson Strutzenberg is a school board member and has been informing you of their deliberations. It is my understanding that he does not officially represent the school board on or to the committee. It would make sense to me if you were to formally request by either a motion or a resolution that the school board formally provide your committee with their opinion as to whether and how they would like to be contained in the city charter, and also ask them when you could expect that information. After all, it would be very embarrassing if you were to recommend that the city council place a measure on the ballot that a majority of the school board opposed, and then as individuals, the school board members then campaigned against it. And it was said that at the meeting of July 25th, the school board did ask the superintendent to plan a special board meeting with both the city attorney and the school board attorney to discuss the Redondo Beach Unified School District and the city charter. I would strongly suggest that you take no action on this item until after they have had that meeting and provided you with their input. I do want to point out that Chairperson Strutzenberg basically said that there had been no action, and it took some of you others to actually pull it out of him that they did ask for that kind of a meeting. That is why you need to really pass a resolution or a motion that formally asks the school board for their input onto this item. Finally, I did read with interest the receive and file memo that was attached to this agenda item. It seems to contemplate a two-step process for retaining school board term limits. First, remove all but the opening paragraph of section 16 from the charter, and then let the school board put a term limits measure on the ballot. I note that this could all be done with one step, a charter amendment that deletes section 16.1 through 16.6, but retains 16.7, the term limits section. There would be no need to force the school board to pay for an unnecessary election as to whether or not they wanted term limits. And if the school board wanted to keep their election consolidated with a city council election, as I think they seem to want, then section 16.3 could be retained as well. But it really makes no sense for you to discuss possible changes to section 16 until you officially hear from the school board as to what changes they would like to see. So I really think that you should make a motion that officially asks the school board for their input on this item, as opposed to just relying on the informal communication that you get from a member of your committee who happens to also be a school board member. Thank you very much.
I think this has gone way past an informal request from the school board. I think the school board is well aware of.
The school board is well aware.
Yeah, so I mean, I'm really addressing this to the public audience, not to us. Whether it's a formal resolution request or anything else by the committee, it's fait accompli. It's already happened. The school board's already discussing it. I've spoken with school board members about it, so. But thank you for your comments.
Yeah, there's no question that it's been discussed. There's just no new action that I have to report since our last meeting.
And the city attorney has tried on our behalf. To meet with their attorney, right, on this issue.
Yes.
And part of the issue, of course, has been they're looking for information. I know we were looking for information at one point. So it's not like they're not moving on the item. It's just they haven't come to a resolution or a point where they're ready to make a decision on it. Fair?
Fair. So that's why, I have nothing new to report.
Motion to, what's the word I want to use?
Didn't you already move to table it?
Oh, that's right. We were taking public comments. Sorry.
We had to
Yeah, we're getting towards midnight. My head's going to get
pause
fuzzy.
for,
So I have who was the second on that? Was the motion? Oh, okay, thank you.
okay. So your motion is to, again,
Adjourn's not the right word.
continue?
Table, continue it. That's the right
is.
word. To the September meeting.
Okay. That's your second? Motion second. All in favor?
Aye.
Any opposed? Okay. I5, discussion possible action regarding the sections of the charter anywhere that mentions any derivative of the word publish. The sections are as follows. I won't read all those out. City Clerk Manzano.
So I brought this. So our issue is that we publish in the newspaper a lot of the ordinances, and it's the whole ordinance, so that can be very costly. And so the committee asked me to reach out to some the cities around the local area. We did a survey, and we found out that majority of the cities that we went to post in the newspaper, and then some post on the website, and then some in physically post around City Hall. However, we found that Arcadia, the city of Arcadia, just recently did, because they're a charter city, changed their charter to no longer publish in the paper. And they put it on their website, and they have 3 locations that it's identified to post around the city. So that's the first thing we found. That was the first city that's actually.
And how long ago was that?
I think it was just, let's see, I have that. It was on the November 8th, 2022 election.
So it's been a year.
Does our-
One of the questions we had was whether or not we could legally
And that,
do that.
the question that the city attorney would be.
Yeah, and so I'll have to research that. So I've not had an opportunity to research that.
And I asked that, how long has it been? Have they been legally challenged in any way yet, is where I was headed with that. And
I haven't heard anything, but we can.
Yeah, I'll check with them, and then I'll check with state law and see if I see, even if they haven't, if I see any potential danger to doing that.
Because the other issue is whether there's a minimum public circulation requirement. I mean, so they sit there and they say, let's assume that there is a requirement to publish it and publish it, period, right? So what's the definition of that? And then what's the minimum circulation? Do you do it from the local, whatever, printing press down the street and whatever? That's, that's the next question that comes to mind is like, what's the minimum circulation that would qualify as being published in a newspaper?
Well, yeah, in Arcadia, it's none, because they're posting it up on 3 places in the city, so.
If it's allowable to put it on a website, that would be the answer. I mean, because everybody has access to the website.
I would agree.
So
that's
I mean,
challengeable because not everybody does have access.
Yeah, not everyone has access, and normally with its if website, then you have to do
that's a
this.
theoretical argument.
Okay.
Okay, you don't know that everybody doesn't have access. Let the person who doesn't have access step up and raise their hand, okay? So that's the first one.
You want me to bring them
My
back?
point is, if you can publish, I mean, the issue of circulation has always been the standard. And we fought these battles. I mean, I fought this battle. And I really don't, it's access. So if you put it out in front of City Hall, or if you put it in front of the two fire stations, or, whatever it is, that's probably better than the circulation of a newspaper in August of 2023. I mean,
And we do post it outside.
I know you do.
Full
I
ordinance.
got that part. But that's
That's a Brown Act
we're
requirement.
wrestling with
That's our charter.
yeah, but
I
we're
believe it's a
wrestling
Brown
with,
Act requirement as
we're
well.
wrestling with what is a publication, publishing. What's the definition of publishing, right? Is that what we're talking about?
Well, what it is, but the other thing is, first of all, do you want to do that? If you can get away with the Arcadian model where you're just going to
Yes.
put
Okay.
a thing, that's not necessarily going to give the most notice for some of the most important things that the city does, like the city budget. That's huge.
Again, that's what websites are for.
Okay.
I have something to add. I think there's a lot to be said about having a third party have record of something as opposed to just the city. So when something is published in a newspaper or on a third party something, I don't know, like maybe library should step up and do something record keeping like this. But when it's all contained within the city, that feels like there's not a whole lot of oversight and checks and balances available.
Well, the idea behind publishing, correct me if I'm wrong, is to give notice to the public through a forum that is most available to the public. So that's why they use newspapers of certain circulations that are representative for a city. And I don't know if they changed the law, but that whoever does the publishing has to be in the inside that political subdivision. So for instance, the Easy Reader, I don't know, do they still have the contract?
Yes.
Okay, the only reason they have the contract is because they bought a newspaper called the Redondo, what was the Redondo? Remember that?
Yeah, but they have changed that.
Have they
That-
changed?
that was one of
You mean
the-
the law?
The law. They
Okay,
changed
so
the law
so-
because they were the only ones, the
Right, exactly.
Redondo
Exactly,
News or
exactly.
whatever.
So-
And
but
so
the-
they changed that.
But the idea, to go to your point, is to expand notice to as many people as possible, right? That would be affected by whatever, like say a contract or a request for RFP or whatever is out there that we need to publish for. But we're really dealing tonight, I think, with the definition of what is publishing in August of 2023. I don't think the old model, as you just said, I mean, in my mind, it was a scam because it was a contract that you paid these people to publish something in the classifieds, and there was a definition of type and size that had to go with different types of notices. So you only gave it to one, well, I guess some cities may have given it to more than one. But for instance, the Beach Reporter was not eligible because they were now no longer in Redondo. The Daily Breeze originated in Redondo, and they're a subdivision of the Beach Reporter. It's a subdivision of the Daily Breeze. But that no longer exists. So my point being, I think we have to think in August of 2023 terms about what publishing is. And, if we can if the internet fits into the model, then I'd say, I would be in favor of saying publishing says you just put it on the website.
I put that out, that's the.
Thank you.
Awfully bright.
Thank you very much. Just
For
pull that right out of your ass.
11:24
Good. That's perfect.
So that's the the legal notices and it has to be the city paper, and you'll see, if you can see, it was amended in March of '03 to
Okay.
eliminate that requirement.
Okay,
And so we
so who's
it
the,
could potentially change that to say, okay, all notices, and we'll have the other sections. This is the preferred way, because we think we can reach more people. But I need to see if there are any limits.
okay, well, then that would be I'd make a motion for the city attorney to bring us a report on what exactly we can do, what the limits of what we can do.
If I could get until October, yeah, that may be tough. I'll try for September.
So September, this is not a high priority item, I mean, I don't.
I would go October, I really don't.
Yeah,
like
Okay.
staying here till midnight.
All right, if I could have October, that would be good.
October's fine with me.
Okay.
I'll second that motion.
The chair, I just wanted to mention on 9.15, it says the city clerk shall cause each ordinance to be published at least once in the official newspaper of said city within 15 days after the date of adoption. So it's a charter amendment that we have to basically do.
And what's our paper of record now?
Easy reader.
Easy reader.
In
So they have
six-
the exclusive,
Every year we have to do.
we give them money, I
Right
got
now,
that
it's
part.
them.
In six
And you-
point,
I'm sorry?
6 point font.
Yeah, right, exactly.
Yeah.
So how is that reaching everybody who is, I'll just say, sight impaired?
I use a magnifying glass.
Okay.
I'm not,
there you go.
I'm kidding. I
I'm
do,
with you.
I got a magnifying glass.
I'm there, I'm with you.
Rumor has it your computer can zoom too.
Yes.
But it's not, yeah, the computer can zoom, but
Probably not Joe's.
I don't think you can zoom. Yeah, well, there you go.
Use the phone.
Control plus.
I use the camera on my phone and I
I'm
expand
very
it.
accustomed to that.
Is the other thing I do. Oh, but yeah, it's not really a very good form of communication.
Okay, so like I said, I would just say we push this off to October and find what we can do. I mean, this really can't be a high, I mean, there's got to be limits.
I'll second that.
I mean, we've opened up, Zoom for public meetings, so, I mean, it's like, I mean,
And there are no e-comments or Zoom for this item.
Next door. Give them some content.
Okay, there's a motion and a second to continue this, was it to the October?
yes. It'll be in November for all I care. I mean, because this is, the city attorney can't make it by October. This is not something that's gonna, a showstopper. I mean, when does the contract end with Easy Reader?
It's every fiscal year.
So you already renewed it, so you've already renewed it.
Right.
So we got a year to do it.
Well, when's the deadline for the next election to get this on? If this is saving us money, I mean.
Yeah, this is saving money. So, it would be, depending if you have an election for the state, we can do it that way, or our March elections in 2020.
It could go on the March 2023, or 2024, excuse me.
March of
We can
2024?
go to
So
any
it's coming up.
election.
So it's coming up. So
I'm not
we
sure.
we don't want to push it
So
off to
November
December.
would be when we'd have to have something before the council at that point.
25. Yeah, whenever you're taking it to council, you can add it whenever we,
But they won't have time to get it ready for a March ballot at that point.
well, for the March ballot, that has to be December, first week of December, it has to be called the election.
Does this come out of your budget?
Yes, everything.
It's a separate appropriation?
No, comes out of my budget. And
I know
Council has
the
to
council
approve.
approves the contract. I know that.
right.
And that's,
It comes out of ours and planning, the legal ad, yes.
Okay.
Is there a summary in here on the cost? What we
So
spend?
it's probably about 20,000 a year. But what triggered this for me was any building changes. It was about 10,000 just for the building code
Yeah.
ordinance. And that's every 2 or 3 years. So
And that's pretty extensive.
that's pretty extensive, yes.
That's just a one-time
Yes,
publishment.
yes.
Yeah, makes that paper thicker.
Right.
How
And
they
the
stay
easy
in
reader loves
business.
it.
Okay, are we ready, Joe?
I'm ready.
All right.
I've been ready.
There's a motion and second on the floor to continue this to the October. And there was a referral to the city attorney, is that correct? You have that for the October? Okay. So all in favor?
Aye.
Aye.
Any opposed? Passes unanimously. Future agenda topics. Anyone?
I would love to be able to come back and revisit Article 15, dealing with commissions, but I'm exhausted that I can't even think clearly on it, so.
I thought that we had talked about that prior and
We did, we ended up saying the council wouldn't vote for it, so therefore we're not going to present it to the council.
okay.
I've got something that's not exactly on the agenda or on the topic, but if you would indulge me. I was reminded a little while ago that yesterday was the 10th anniversary of John Parsons passing away. I was in council chambers when John had his stroke, and for all practical purposes, he passed away that night. Those of you who don't know John, he was probably the most community-oriented person in Redondo Beach, was a great supporter of Redondo Beach and everything in the South Bay, and gave an awful lot to this city. So 10 years ago.
I would echo those same comments. He was right up there was the leading candidate for Mr. Redondo. That's correct. A cheerleader, and he fit well in almost any role that he took up. Chamber of Commerce, realtor, council person. Yeah, that's,
That's it.
So do you think we should adjourn in his memory?
It's
I
up to
would.
you.
I would.
I would, sure.
Yeah.
We can do it, it's fine. For the September agenda item of city treasurer, would you add the following documents? The July 1st, 2014 city council minutes, agenda, and attachments for item N4, including any blue folder items. For the July 15th, 2014 city council meeting, the city council minutes, agenda, and attachments for N1.
Is this from the city council meeting?
Yes.
N4, okay.
So July 1st and July 15th. Minutes, agenda for July 1st, attachments for N4, including any blue folder items. For the July 15th, attachments for item N1. And then regarding Measure CT, which was November 4th, 2014, can you find the ballot language on the, this is about the city treasurer, the impartial analysis and any arguments in favor or against or opposing, as well as the actual, we had talked about this before, the actual charter language change, which would have, I believe, had to have been included as part of the ballot.
Okay. Is it?
Okay? Any other referrals? And I put that as a future agenda topic because it was a mix of that and a referral to staff, but it is a future agenda topic for September. With that, I will entertain a motion to adjourn in the memory of Mr. John Parsons.
So moved.
So moved.
Second?
Moved in second, all in favor?
Aye.
Aye. Passes unanimously. Thank you, everyone. Meeting is adjourned, 11:34.